Let copy be served upon the learned advocate representing the contender in court. Start. What steps have been taken to comply the court's order?
Lordship, till dates, my instruction, no steps has
Nothing.
nothing. So for the disposal of the representation is concerned, Lordship, no reason order has been communicated.
Why did you file the writ petition after such a delay? The contempt?
This order was passed on.
17th of May 2024.
Yes. Now the writ petition, the contempt application was filed in
August 25. Let the contempt application
22nd May 2024. I served the contempt
appear in the list once again on 19th January 2026. An affidavit of compliance shall be filed with
the instruction and the other points are there because you pointed out why 2.5 years.
2nd June 25.
not 2.5 years.
That is 1 year is actually your loss.
Not 2.5 years.
I am only seeking that is except for the compliant.
All right, let us see what you've done, because he says you have not done anything. You've not done anything. Be filed with an advance copy to the learned advocate representing the petitioner. Jalpaiguri.
Murad, I am appearing for the commission.
Please, Jalash. Brief দাও আমার নোট খুঁজে পাচ্ছি না before start কেন খুঁজে পাচ্ছি না গো
Yes.
Before start with the matter, my lord. Here, my lord, the contention of the writ petition, my lord, fully covered by your lordship order passed on 27th November 2025. My lord, I annex that order, my lord. Page P8, my lord, that is at page 78. Here, my lord, your lordship was pleased to direct council to consider the and giving my lord the benefit of the caste certificate of the scheduled caste and scheduled tribe, irrespective of where my lord they are choosing their caste status in a drop-down method, my lord. Here also the same case was happened, my lord. Here the writ petitioner is belongs to my lord scheduled caste category, my lord. When he applied for the second SSC, my lord, then that point of time he
Show the application form.
my lord, the application form has not been annexed, but I annexed the caste certificate of 25 and I made amendment in paragraph number, my lord, 4.
Application form.
Application has not been annexed.
No, page 52.
Page 52, I can see that.
My lord, I'm sorry, my lord. This is I'm bringing for your apology, my lord. Page 52. Page 52.
Yes.
Here, my lord, when preliminary interview list has been
What
published,
is
my
the
lord.
status of the appeal that you filed?
My lord,
Appeal.
my lord, tomorrow date has been fixed because
All right.
Mr. Dhar took time. Tomorrow date has been fixed at the instance of Mr. Dhar.
What to do? I post it tomorrow?
No, tomorrow, day after tomorrow.
Day after tomorrow? Please come.
My lord.
the petitioner seeks relief in terms of the judgment delivered by this court on 27th November 2025 in WPA 26937 of 2025 in the matter of Somnath Pramanik and others versus the state of West Bengal and others. Paragraph. It has been brought to the notice of the court that an appeal has been carried from the said judgment and the same is likely to be taken up for consideration by the Honorable Division Bench tomorrow, that is 11th December 2025. Stop next. In view of such submission, release the matter on 12th.
My lord. Only one thing, my lord, this is a Jalpaiguri bench matter. I think coming week, my lord, bench will sit over there. So
I'll send it there.
no, my lord. My lord, I will pray before your lordship that your lordship, my lord, hear this matter.
Let us see Friday if something happens, otherwise it will go there. Yes, call the list, please.
The daily leave. And for the petitioner, my client do not want to proceed the matter.
Give me the written instruction. Yes. Dismissed as not pressed. The communication is here. There is a connecting application. Please dispose that also.
Item number 2.
What is the correction to be made? What is the correction? Correction টা কি হবে? One 4925. অর্ডার হবে, আমি কারেকশন করে দিয়েছি, করে দেবে। Item 3, urgent motion. দেখি none appears on behalf of the petitioner.
Well, I am for the state in this matter, Lordships.
It was mentioned as urgent and that is the reason it has been upgraded and now see nobody is there.
But they state tomorrow, Lordship, we fix the matter, Lordships.
Tomorrow?
Item number 32 is the Monday list. Item number 32.
Yes.
But item number 32 in the Monday list, Lordship. I think so, Lordship. The matter is fixed by his Lordships.
No, is this matter due to appear today?
But Lordship, the fix the matter in today, Lordship.
None appears on behalf of the petitioner at the time of call, though the same was upgraded citing urgency. Stop. Learned counsel, you are for the state, Mr.
I am
Bush.
for the state, Lordship.
The state is represented. List in the combined monthly list of January. Next.
I am for the petitioner.
Lordship, I am for the state in this matter, Lordship. The matter
Lord, in
was
this
heard
matter.
before his Lordship. The matter
Well,
was heard before his Lordship. Lordship directed to rectify the DI report. Thereafter, Lordship, as per your instruction, Lordship, DI rectified. He is the eligible for the compassionate appointment, Lordship. Kindly see the report, Lordship.
The petitioner, my lord, provided one corrected certificate from the. It is from the
Issued by
video. My lord.
Please come. It has the petitioner seeks compassionate appointment. Stop. The as the claim of the petitioner for providing compassionate appointment stood rejected by the District Inspector of Schools, Secondary Education, South 24 Parganas, on the ground that at the material point of time, the family income of the petitioner was more than the initial gross salary of the Group D staff. Group D staff of the state government. Stop. Next. Today, the learned counsel representing the state respondents has obtained instruction, has placed the instruction forwarded by the District Inspector of Schools, Secondary Education, South 24 Parganas, dated 4th December 2025, mentioning that the calculation relying on which the claim of the petitioner stood rejected was erroneous. Stop. The DI has opined that the petitioner would be entitled to be considered for compassionate appointment. Stop. The case of the petitioner for providing compassionate appointment is already under progress. Case prayer of the petitioner is already in progress. Next. In view of the above, that the DI has brought to the notice of the court that the prayer of the petitioner seeking compassionate appointment is under active consideration. Accordingly, the instant writ petition stands disposed of by directing the DI to proceed with the application of the petitioner seeking compassionate appointment and reach the same to its logical conclusion in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If the petitioner is found to be entitled to the appointment, then necessary consequential steps shall be taken without any further delay. Stop. The impugned order of rejection dated 16th August 2022 by the District Inspector of Schools, Secondary Education, South 24 Parganas stands set aside.
Only prayer plus some shorter time, nothing more. Yes, I've received the copy.
12 weeks time has been given, Lordship.
Yes.
Instead of 12, some
Yes.
shorter time.
I am grateful, Lordship.
I say at the earliest.
Yes, my lord.
And the outer limit is 12 weeks.
Yes, grateful, Lordship.
My lord, I beg to appear on behalf of the petitioner in this matter.
Yes.
This is the exception to the report filed by the commission. This is regarding the model answer key and question in this subject nutrition. My lord, at the very outset, I submit that I challenge 6 questions in the writ petition, but with all fairness, I submit, my lord, 2 questions I did not raise objection, so your lordship may not even take into consideration those 2 questions. I stand clear on my submission. Now, in regard with 4 questions and answers, I submit. My lord, 2 questions, they raise a point in their report that I had not raised objection. My humble submission is that I could not raise objection for the reason the preliminary model answer key was changed at the final model answer key. So I had no scope as per rule 11 to make any challenge to that. Those two questions I'm entitled for marks. Now remaining two questions, my lord, I posted with the text book support. Now kindly see how these two questions have been dealt with. Kindly take the report for once, submitted by the commission. Yes.
Yes.
Yes, my lord. My lord, if your lordship kindly comes to page number 26. It was not paginated in my copy, but I have. My lord has found a list because it is not page.
It's a chart.
It is
Is it a
art 2.
chart?
Yes, yes, art 2. Yes. My lord, kindly come to serial number 40, left hand side.
Yes.
Right hand side, your lordship will find challenge count 867 challenges were made. It is not me only. Those who have come up with the challenges, and 867 candidates supported their challenge with textbooks. 1. Now, my lord, kindly see right hand side, correct answer as per challenge. Question is wrong or out of syllabus. It is what they are taking. Lordship has found at the right hand side 40.
Yes. 40, 867 objections. A
Yes.
is the uploaded answer, means A is the correct answer.
Uploaded answer A, yes. And correct answer as per challenge that they are taking is correct. Question is wrong or out of syllabus.
Yes.
Lordship found. Similarly, my lord, kindly come to 52, serial number 52, just below.
No, then what is going to happen if the question is wrong or out of syllabus?
No,
Everybody
that is a secondary question. First question is there are 6 counts of challenge. Commission allowed 6 in the drop down box. We could click any 6 options, which will be appearing from the page number 28, based upon which they had made their consideration, if at all. Kindly come to page 28. Kindly see this is a mail communication between the authorities. Kindly see on these Roman 6 grounds.
Yes.
My grievances can be considered. Romans these 6, because these 6 come in the drop down box.
All right.
Now, my lord, when I challenged in this question with one of the 6 different options, but they have not considered it. At their whims and fancies, they have taken only question is wrong or out of syllabus. Therefore, my objection remains uncontroverted, undecided.
I didn't get it.
I tell your lordship. My lord, your lordship has seen they have taken only.
What was your ground of objection?
Yes, my ground of objection was within these 6, but not what they have taken in
What
page.
is your ground?
Yes, I'm coming to your lordship. With this, my grievance was, this is regarding question number. This
Question number 40.
No, this is this possibly is the master key. This is how they have been given. In respect of the master key, the question is to be taken into consideration. My submission was they have taken A and C, both are correct, but model answer key has taken C. So I have given that both my objections are correct. Both the answers are correct. So you cannot take only one model answer key, what they have stated, because we have supported with the textbooks. But what they have converted it into, they have converted into question is wrong at all, and for which they have given marks to all. Your lordship has already considered there are 2 types, marks to all and marks to attempt. Cannot be. Marks to attempt, there has to be an attempt, or even if you are getting beneficial marks, you have to attempt. That I will show subsequently. But they are giving marks when there is a particular answer available. You cannot treat this question as a wrong or out of syllabus and give marks to all. So you are diminishing the competitive edge and, my lord, the level playing field. 1. The second one.
1 minute.
Yes.
The according to the experts, right? Page 26, the question was wrong or out of syllabus.
Yes.
Either of the two. You did not object on this ground.
No.
Your ground of objection was something else.
Another option is correct.
Something else,
Yes.
right?
Yes.
Now, how have they marked? They have given marks to everybody who's attempted.
Yes. Whenever it is question is wrong or out of syllabus, they have given marks to all.
Right.
Cannot be.
It cannot be. You say that
There is a specific answer supported by textbook. You cannot give marks to all. It is when there is a specific answer available. You are destroying the level playing field by that.
But then 867 objections were filed.
Now 867 objections were on different count.
Yes.
I am suppose I am
One of you.
867th can
So if 867 candidates have different grounds of objection, they have to come to, experts will come to a conclusive opinion.
absolutely. Now they have to, when it is supported by textbooks, they have to take the model answer key, either option A and C or both. They cannot say the question is wrong altogether. Now 867 question, where is the consideration of my objection? It is not. I pose this question to myself. My objection was that you cannot take option C only.
There is a specific answer. This was your objection.
Specific answer.
Right.
Yes.
The authorities found that no, that the question is wrong.
They found the question is wrong. Question is not wrong at all. There is a specific answer to the question.
I do
Supported
not
by the
know. It
textbook.
is the experts' matter.
No.
How will
Yes.
the court decide on this?
Since it is the provision under Rule 11, the expert has to give their mind in application, that how they are deciding it. I'm showing you, Lordship, how they have decided. Now kindly take the 52. This 839 objections came. Kindly take page 26.
26, yes, I am in 26,
Kindly
52.
take the 52.
No answer is correct.
No answer, it cannot be. Now, my lord, I'm telling you, Lordship, this the answers are given, specific answers. There are options. We have given the books. See, it is written in the book. This is the answer. You cannot say no answer is correct and give marks to others. One. Now, my lord, since I showed to your lordship that page 20, there are 6 grounds. You have to consider 6 grounds. You cannot only stick to one, because you are only giving the option of 6 grounds.
How do you know they have stuck to only one? They must
Page
have
20,
considered all.
page 20, no, they have taken only one. That is page 26. So my objection that the option A, option C is also correct has not been taken into consideration. They are at their own whims. They have taken that no answer is no answer is correct. Now there is no adjudication on my
just
submission.
fail to understand how can questions be set with no correct answer.
Exactly.
This is just not
Cannot
in my coming to my mind.
Cannot
A
be.
competitive examination, questions are set where there is no correct answer.
Exactly, madam. When there is actually correct answer. By doing this, they are giving marks to all. Now, my lord, kindly come to page 29. Kindly see page 29. This is the, thereby they have stated there are 29 objections raised regarding 29 questions. There is only 9 they have taken as per their report. This is the adjudication. I won't say adjudication. This is the decision they have taken in regard with those 9 questions. Kindly see where my question, my objection does not feature even. This is their document. They are relying upon. Kindly see C and A are both correct. It is not correct. I have raised objection.
No, you must have raised objection, but the authority found, the experts found that C and A both correct. Question
But
number
when I have
3,
raised
that
an
one
objection,
answer.
I am not talking about other 20 questions. Why they have rejected other 20 questions, I do not know. It should have been mentioned here that we are not accepting other 20 questions for this reason. It is not there. They're completely silent. That no, 20 questions, we do not know what they have done with. Now they have, at their own expertise, they have taken 9 questions. What about other 20 questions? We do not know. Now, when I'm coming to this, I can show to your lordship from the
1, 2, 3,
model
4,
answer
5,
key.
6, 7, 8, 9, 10. I can see
Yes.
page 29, 10 questions.
Yes. Now, my lord, kindly, it will be helpful if your lordship take the writ petition once, the model answer key. It will be easy, my lord. Kindly take.
Yes.
Kindly come to page number 78.
$78.
This is the master key. My lord, your lordship will find.
Yes.
3, I'm giving one option. 3, my lord, C has been given.
78. 3 C.
C was, now kindly come to the preliminary model answer key, page 77.
26.
6A, 26. That is C. Your lordship,
I didn't get it.
yes, I'm showing your lordship.
3.
3.
26. What is this 26?
This is the, my lord, question number.
Question number.
Question number. They say option C at page 78. Now kindly see the model answer key at page 74.
Page 77, 3, you show 26. What is this?
This is the question number.
Question number 26.
Question number
What is
20.
the answer?
In the master key, my lord, kindly see it is C. Option C.
26.
3, your lordship, take master key 3C,
Page 78.
78. C,
26, I can see D.
no. Your lordship have to take 26 is the question number, master key number is different. Master key question number. Kindly take page 78. Take 3. Take 3, my lord. This is the master key.
3 is the master
3
key.
is the master key. Kindly
Right.
see the heading, master key. At the
Yes.
top, master answer key. 3 is the heading. C is there.
Yes.
Option. Now kindly come to page 77.
Yes.
Now in respect of, my lord, kindly see the left hand side 3, master key 3. In the A booklet series, question number 26. 26 is the question number. Right? Now kindly come to page 74.
Answer is
A and C.
26 is the question number.
No, 3. Master key 3. In respect
Oh,
of master
3.
key 3.
A and
First
C.
now
both.
A and C both.
Ah.
This is one. Now it changes at the final round. A and C. They take. Now, my lord, in regard with my other questions, that is at page number master key 13. Kindly take page 78. I raised objection regarding this 13 also. Your lordship will not find it in page number 29 of the this report, page 29. Equally, 32, when they have given option D, it says in 32, no answer is correct. If your lordship kindly takes page 29 also of the report.
29 question.
No, 29, page 29.
Page
Of the
29.
report. Of the
report. Yes. Question number.
Kindly see this 13 does not feature.
13. No answer is correct.
No, in the page number 29 of the report. Kindly take the report. Page 29.
29 of the report.
Yes, kindly left hand side are the master keys. Kindly see that my question 13
Is
doesn't
not there.
feature. Now, my lord, equally, my lord, 32, they say no answer.
What is page 29? These are the
They have
questions.
Out of total objections, 29 questions were objected. They have taken only 9.
This is 10.
This is the page which shows they have adjudicated upon these 9 questions.
Where is 9?
No.
10.
10. They have stated 9 in their affidavit.
All right.
10
questions.
questions. 10 questions. I take 10 questions. Now my objection is not there here at all. That means it has not been considered at all. There has to be a consideration because Rule 11 says suggestions and objections. When I've raised objection, I deserve to be considered by them. They have not considered equally, my lord.
What are the questions that you objected to?
Yes. Kindly come to page number, my lord, 6 of my writ petition, page number 7.
Yes.
This is the first question. The preliminary model answer key was C. I gave answer C, but in the final model answer key, A and C both. So those who have given A, they are also getting marks when there is a specific answer supported by textbook. Now, my lord, kindly come to page number 8.
The books that you are relying upon,
Yes.
have you annexed copies?
Yes.
Are those ISBN numbers there?
Absolutely.
Who is for the state? You.
Yes.
Where are the numbers? Show me whether these books are taught in the state government schools and whether the state government is approving these answers or not.
There is no specific notification regarding ISSBN, but I have read on all the journals and ISSBN. I'm showing to your lordship. Kindly come to, my lord, page number 82. ISSBN, ISSSN, and TB. 3 types of questions books are allowed. ISSBN is the national, ISSN is the international, TB is textbook. There are 3 classifications. My lord, your lordship, at the left hand side bottom will find the ISSN number. This is the ISSN.
82.
Page 82.
0012.
Yes, this is the ISSN number. It's 6. I will show. The other documents are also available. The kindly take the summary portion. Role of zinc in insulin biosynthesis. The summary starts from the summary. The behavior of proinsulin and insulin in presence of zinc suggests it plays an important role in insulin's production.
No, no, we are not going into all those things.
Yes.
Right? You say that this book is a recognized book. State government schools follow this book. And despite this, the answer that has been provided by the experts of the commission do not tally. This is your case,
Yes, there are all the documents. Yes, yes. They have,
right?
yes. No, that comes at the second round. They have not even considered my objections.
All right. Give me the questions where you objected to.
Yes, my lord. It would be evident, my lord, from can you take the report itself?
Report.
Yes. My objection.
4 questions.
4 questions. I repeat
right.
myself to 4 questions.
Yes.
That is corresponding to, my lord, because the booklet series are different. Kindly take page 19 of the report. Kindly, your lordship will find that A32, this the second one.
A32.
Yes, that I objected, my lord. And the next one, A51. My lord, I kindly see A32 for once. Commission uploaded model answer A, suggested answer by the candidate D.
A32 was considered by the commission.
A32, we have to see the master key now.
Check up and
Yes, yes,
say,
yes, I'm
because
checking.
they have given the questions considered.
I'm giving, my lord. I'm giving. This is serial 40. No, 40 is not there, my lord. 32's corresponding master key is 40. Question number, just a minute. Yes. 32's question number 32's corresponding master key number is 40. But in page 29, I do not find 40 is there.
All right. So, page 19.
19.
This question booklet A, question number 32, AD, objected to, not considered.
Not considered.
Very well. Next.
Now 51, kindly take A51. Suggested answer by candidate more than one
In
answer.
51.
Just below the.
Yes, A51. See, more than one answer is correct.
But kindly take into consideration these options we do not write. It is what they provide, we click. Like more than one answer is correct is not written by me. It is their option given to me.
There are many options you
6
chose.
options. 6 options.
Right, you chose
I chose this.
Right.
I chose this.
Hmm.
So I do not have my right to write anything.
No.
Yes.
There is a drop down and you select
Drop down.
this.
Yes. Otherwise, I could have written more. I could not explain.
You could have written an essay over there as
Essay
to
over
why.
there. Yes, exactly.
That is the reason they have
given.
that drop
Absolutely.
down.
That's what I'm trying to say. A51, my lord, kindly see this question number 51. The master key would be 52. It will not appear in the
Page 29, it's not there.
page 29. 52 is not there.
Right. Next.
Next, my lord, these 2 questions are for this petition number 2. Yes. Next is, my lord, kindly come to. I'll get there. Just a moment. Yes. It is at page number 8. Kindly come to page number 8 of the report. Page number 8, R1.
Yes.
My lord, kindly see at the top C12. C booklet series, question number 12.
Hmm.
SSC uploaded model answer A, suggested D. Now C12 is, my lord, this is 40. This would be corresponding to 40, master key number 40, equivalent to question number 32.
This is also not here.
Not here. 40
Alright.
is not there. Now, my lord, kindly see 30.
The fourth one.
The third one, C39. Just in that page.
Yes.
C39, kindly see uploaded model answer C, suggested answer by candidate A. Which C39 is, my lord, C39 is 52, master key 52.
This is also not
Also
there.
not there.
So none of your objections have been considered.
And these 2 questions, these corresponding questions is, now 2 questions I did not get the opportunity to lodge from object because it got changed at the final round. And 2 questions not been considered. And very vital, my lord, kindly take page 74 for once. Kindly 75. Kindly see.
Yes.
My lord, kindly see the left hand side column itself. That the second left hand side. Marks on attempt. Your lordship has found. And kindly see below marks to all. And again marks to all. their marks on attempt. Now
Please, I'll inquire what it
yes,
means.
this is my humble submission. What do you mean by marks to all and marks to attempt?
Yes,
Marks to all means,
this the commission will explain.
yes, why I have put up this issue before your lordship, because marks to all means even if I do not attempt, if I look at it, I'm entitled to get the marks. And marks on attempt means I have to make an attempt. I understand marks on attempt, my lord, it is not altogether wrong. Why I'm making this submission humbly? It is not altogether wrong. If the question is itself bad or wrong, or the answers are wrong, then candidates are eligible to get benefit of doubt marks. I'm not standing in the way. When it is actually wrong, but when there are absolute
Correct answers to
answer,
it.
you cannot term it as a wrong and you give marks. Now I have objection with marks to all. Even if the person is not attempting, can he get the marks? I pose this question to myself, my lord, I just humbly. These are my humble submissions before lordship regarding 4 questions. 2 I'm anyways, my lord, 2 I'm entitled to get marks because I did not get the opportunity. For rest 2, my lord, my questions have not been considered. My suggestions have not, objections have not been considered.
Yes, the commission, please.
Friend, is that which I have understood in my own way, that granting marks to the persons who have objected to, they have not given the correct answer. Therefore, he is basically against the awarding of marks to others. He has made these submissions. Now, let kindly take my report. Kindly come to page. No, page. Compulsion of objections. First, Millard, kindly see page 26.
Yes.
Millard, this is the compilation. Millard, grievance stated. The subject 1, nutrition 9, upload answer C, correct answer as per challenge. More than one answer is correct, more than one answer is correct, more than one answer. These are the Millard. Total is 59. Total is 59. Now, Millard, kindly come. Now, Millard, kindly come to yes, page 29.
It's 25.
Page 29.
29.
Kindly see C and A are correct, both correct. 8, there is mismatch between correct in option B. Then question is incomplete, etc., etc. Your losses will find 3, 2. There are some reply has been given here that what are the correct and what are the not correct. Let's see the last sentence which has not been read to your losses. The answer for rest of the question which were referred to remain unchanged. About the above this which are there, that have been changed. But my learned friend is saying no question number 51, no answer is given. Question 52, this expert committee has not considered. This is not correct. Last 2 lines are complete, that the accepting this all are remain unchanged. Now your lordships kindly come to his objection. That's we have said so. No, it has Lord, kindly come to page 3 of our report. Well, kindly see, we have given the chart. Petitioner number 1, booklet series C, 12 series C for master. Petition number 2, booklet series. Challenge during objection. Correct answer will be D and not A. But in paragraph 6, Roman 3, the petitioner contends that both A and D are correct.
Exception to
Therefore, that is in the writ petition, he has said so. Next, my lord, question number 16 and question number 7. Correct answer will be D and not C, challenge during objection. Not challenged. Whether challenged in the writ petition, not challenged.
No, I did not.
Then, my lord, 3. Question number 39, series C and question 52. Question 51, series A, question so and so. As per petitioner number 1, challenge or during objection, as per petitioner number 1, correct answer will be A and not C. And as per the petitioner number 2, the question has more than one correct answer. Therefore, my lord, contradiction is there between the two petitioners itself. Then kindly come question now, then serial number 4. Question number 41, series A question. Correct answer will be D. Preliminary model answered by is suggested the same answer, hence this challenge had no meaning. Not challenged. Has not challenged. Therefore, my lord, what is happening? My lord, after the preliminary, the answer is given, objections are coming. Your lordships have seen the list. How many objections will be still? Kindly come to page 26. Page 26, we are dealing with, kindly see, subject 1, 2 is 571, 19, 363, 37, 37, 10, 134. So many objections have come, and these are expert body has seen that, examined that. I have shown your lordship the that page also just now. That is that page. Kindly see, page is 39, 29. Now, my lord, the lordship knows, my lord, I have already argued to your lordship, my lord, I have shown the judgment. I do not want to repeat. My lord, the court will not go above the expert committees. That's the settled principles of law. And he is trying to unsettle everything. Those who have got the number, why they will get the number, fair play, equity. Now, I have to consider everyone's objections. I have taken notes of everyone's objections, send it to the expert committee. And my lord, kindly come to page 28. Well, kindly see, this is 24th October 2025. We have written to the experts. This to have solicited kind assistance as an expert for reviewing the preliminary mode answer keys of the recently concluded so and so. We uploaded the preliminary as suggested by paper setters, moderators after the examination, and the review exercise is being carried out in terms of the extent rule. The grievances are basically of 6 types, though all of them may not be relevant to you for your subject. Grievance that the choice in the preliminary key is wrong, so and so option. Grievance the more than one choice of the preliminary key are correct. Grievance that more than one choice in preliminary key is correct. Grievance that the question is itself is wrong. Grievance that the question is out of syllabus, and grievance that the English version and the Bengali version will carry signifying different meaning. Now, where the question is totally incorrect, what the expert has said, their number has been given to all. That is not an, if he says, no, why he will get the number, that is not the writ petition is about. Then they let him, they made party, they will contest it. Now, another one, Millard, there are questions made wrong. Someone attempted, someone not attempted. Who has attempted, their number has been given. And Millard, your lordship's query is that in the why, how can be the questions can be said to be banned? Millard, this is a regular phenomenon. Your lordships will find in the joint entrance examinations. I can give your lordships the chart even. Millard, there is also AIB, All India Bar Examination. All are there, Millard, if you lordship. But this has happened. This is not expected, not No doubt it is not expected, but it has happened, and this is the procedure is followed in every examination. And I will request your lordships, my lord, not to interfere with the writ petition, my lord. I have cited the judgment earlier also, but just to 2021 3 SSC 209 209.
How many questions are there in the written examination? 60?
60.
60. And page 26 and 27, I see 29 questions out of 60 are objected to.
Yes, objected to, then it has been referred to the expert committee.
And the expert in
Expert has given that, my lord, at page
26.
29, my lord. Page 29. Kindly come to page 29 of my report. Can I read, my lord?
29.
Yes, page 29.
9 has been found to be proper.
9, question number 9. Your
No,
lordship,
no.
yes.
Page 29, there are serial
Yes.
number 9 serial numbers, 10 serial numbers total.
Yes.
3, 8,
1,
8.
2, 3, 4, 4, 5, 6, 7, 8, 9, 10. Right, my lord. And rest are right, correct answers.
29.
Yes.
Now, my lord, kindly see, my lord, the judgment, my lord, that which I wanted. 2021 3 SCC 209, paragraph 14 to paragraph 17.
No, you can download card.
The content.
Paragraph 70.
Paragraph 14, my lord, thus rehabilitation can be directed if rules permit. This court has deprecated the practice of rehabilitation as scrutiny of the question by the courts which lacks expertise in academic matters. It is not permissible for the High Court to examine the questions papers and answer sheets itself, particularly the High Court to examine the question papers and answers when the Commission has assessed the intrinsic merit of the candidates. Courts have to show deference and consideration to the recommendation of the expert committee who have the expertise to evaluate and make recommendation. Examining the scope of judicial review, there's so many things have been given. I am not reading, but kindly come to paragraph 17. But paragraph 16, kindly see. In view of the above law laid down by this court, it was not open to the division bench to have examined the correctness of the question, and the answer key to the come to conclusion of different from that of the expert committee in its judgment is so and so. Reliance was placed by the appellants on register so and so. In the said judgment, this court interfered with the selection process only after obtaining the opinion of an expert committee, but did not enter into the correctness of the question and answer. The perusal of the above judgment would make it clear that courts should be very slow in interfering with the expert opinion to academic matters. In any way, an assessment of the questions by the court itself to arrive at correct answer is not permissible. The delay in finalization appointments to public post is mainly caused due to pendency of cases, challenging selection pending in course of long period of time. This cascading effect of delay in appointments of the appointment on temporary basis and temporary, the other consequence resulting from delayed appointments. Now, this is the one, my lord, and similar order, my lord, your lordship has passed an order. Kindly give it. That's on 27 November 2025, my lord. Onimesh Chattopadhyay and others. After paragraph 750, after hearing the submissions made on behalf of the parties, it appears that out of 6 prisoners, 3 of them did not raise their objection within the stipulated time to answer. The objection raised by the candidates were considered by the expert body and final answer key has been published. All the appearing candidates have been marked and the result has been published. There may be candidates who are not satisfied with the evaluation by the expert committee. They may have study materials in support of their objection. The candidates at the time of participation in the recruitment process were aware that the declaration of result by the expert committee to be treated as final and binding. If the prayer of the petitioner is allowed for re-evaluation, then the same will be contrary to the recruitment of published placement. The unsuccessful candidates who may objection in respect of many or even one question will rush to the court seeking an evaluation. Such practice has not been appreciated by the Honorable Supreme Court. The court is not expert body. The court is also not inclined to appoint insurance. This is also your lordship's order. But therefore, I will be requesting to your. Okay. Just 1 minute, below. Well, he has not. The page 82 of the writ petition. Well, this is a copy of the journal, international journal. This is not book.
ISSS number.
Madam, the journal. Therefore, this is not correct. Whatever it may be, I am not on that. That any books have to be considered now. Any expert other than any standard books have been written. But we have to depend upon the experts. We have decided on the basis of the experts. Huh? And it is. If it is out of syllabus, then some answer is correct and so marks are on attempt has been given. But these are my submission to your lords.
My lord, kindly take rule 11 for once. Kindly see rule 11.6. Possibly hand it over.
Well, consideration doesn't mean the consideration the way the candidate is thinking. That is, and here is a consideration has been made. Consideration cannot be made challenged in that way. Here we have shown to your lordships all objections have been sent. To consider means not until he likes. Well, kindly appreciate another one thing. Appreciate one thing. He may be dissatisfied. But so many persons have satisfied. He may be dissatisfied.
Kindly take rule 6. It is very categorical. The Central Commission shall form a subject-wise expert committee comprising not less than 2 members in the rank not lower than professor of college university. Now, the expert committee shall deal with the suggestions and objections. The word is deal with the suggestion and objections, if any, received from the applicants. Kindly take a pause here. The statutory obligation is that the expert committee has to deal with the objections raised by the candidates. So, my lord, I have established before lordship that 2 questions they have not dealt with. One. Now, kindly take page 29.
How do you say they have not dealt with?
Because page 29, I showed this 52 and 3, this 40 master key, it is not there. They have not even dealt with. Now, my lord, kindly see the last paragraph.
The answer to the rest of the questions, page 29, remains unchanged. There
has to be an application of mind. They cannot say, no.
How do you know that they did not apply mind?
Because they have to come up with this. The way they have come up with the other 9 questions. They say C and A are both correct. There is mismatch between various in option B. Question is incomplete. They have to come up with the reason that why they are not taking other options, other objections. Because the
you cannot expect that they will write an essay after dealing with your question.
Absolutely not.
Then
when the statute gives a provision that they have to deal with the objections, they have to deal with it.
They have dealt with and they have come to a conclusion that they
for 9 questions they have dealt with. I have no problem with that. They have 9 questions, they have given reasons. But what about my objections? These two.
Your objection falls within page 26. Whatever you objected to, 867, 839.
Well, it is not there. Kindly see page 29, they have not dealt with. It is mentioned, it is the digital copy. That who has objected what, that is the number, this is a data sheet.
Now page 26 is the data sheet.
Data sheet, there is only the data sheet. There is no decision making on that. Decision making is on page 29, where my lordship will not.
The others have been found to remain unchanged, which means they have dealt with and found that whatever is there is there.
My respectful submission. If they are saying in 2 lines that it remain unchanged, what is the reason for that?
That means they have to write an essay.
No, at least 1 line for which they have written for the other questions above, that it is mismatched, it is correct.
Where there is a change, they have written. And
Yes.
where there is no change, they have not written it.
They have to come up with, because there's a textbook support. They have allowed textbook support. They have to see, no, your textbook support is wrong. You are giving the wrong book. Your book is not correct. Your answer from the book is not correct. That is exactly the purport of 11.6. They are allowing us to upload the books. That means there is a scope for consideration on the books I have uploaded. This is my respectful submission. Now, my lord, kindly take paragraph 12 of the report, what the commission has stated. Kindly take page 12 of the report. Page 7, I'm sorry, my lord, page 7, paragraph 12.
Page
Page
7
7, paragraph 12
of the report.
of the report.
Yes.
Kindly take the second line sentence. The entire examination process does not deserve to be derailed only because some candidates are disappointed or dissatisfied. Very well. Or have perceived some injustice having been caused to them by an erroneous question or an erroneous answer. My lord, I leave it to the conscience of the court what they have exactly meant by this.
Because they admit that the questions are wrong.
They are
The
saying have
answers are
perceived
incorrect.
some injustice. Kindly see the word they have used in their affidavit. Have perceived some injustice having been caused to them by an erroneous question or an erroneous answer.
That
Meaning
means they say that the injustice has occurred.
even if you are you have suffered injustice, that doesn't matter
Mm.
because the recruitment is going on.
Yes.
It is, I'm very specific on this statement, my lord. They would not have given this, but since they have avoided this, somewhere in my respectful submission, I leave it to the conscience of the honorable court. Somewhere there is some hint of, some smell of something wrong, erroneous, which has happened. For which they are saying, even if you have perceived some injustice, having been caused to them, they're specific by an erroneous question or an erroneous answer, but you cannot derail. Lord, I have not come here to derail the recruitment process. I have come for my marks. They are not doing charity to me. I have come for my justified marks because, my lord, the statute says there has to be dealt. It has to be dealt by the expert committee in support of the textbooks. Now, I pose this question to myself: that why the statutory provision says that you upload the textbooks? There is some purpose. The legislative intent is very clear that based on my textbooks, they will have to come to a conclusion that no, your question, your objection is incorrect. The books you have suggested, we are not accepting this, that, whatever the reason they have. There is no, they just two lines, they say it remains unchanged. This is a non-speaking, if we use the word non-speaking order, it is not an order, but it is a non-speaking observation, not remain unchanged. What, for what reason unchanged? Have they decided I'm not seeking for an essay? But what about the other questions you have dealt with in the same fashion? Just 10 questions they have dealt with. At least they should come up with the answer. They have not arbitrarily. It's not considered. Remain unchanged. That's all. And my lord, in the list which was shown, kindly, your lordship will find there are only 4 questions. Right. In page 4. 2 of them I did not even, at the very outset, I said I'm not objecting to that because I'm only concerned. And there is no response in regard with those 2 questions which I did not get opportunity to correct. Because this report is also silent on that point. These disputes is regarding 2 questions, I understand. What about 2 other questions where I did not even get the opportunity? How will they challenge that? If it is changed at the final round, that is the question number 26 and 59. I did not
come. The petitioners participated in the second SLST within bracket 80, 2025. They are aggrieved by the manner in which the objections raised by them after publication of the preliminary model answer key was dealt with. Stop. 2 of the questions answered by the petitioner tallied with the answer provided in the preliminary answer key, preliminary model answer key, but they got changed at the time of publication of the final answer key. Stop. The petitioners rely upon study materials in support of the submission that the answers that they have marked in the question booklet are proper. Step. Paragraph. The learned advocate representing the petitioners draws attention of the court to the final answer key, where there are questions having more than one answers, and there are questions where marks have been given to all and marks given on attempts. Stop. It has been submitted that providing marks to even candidates who did not attempt the answer is highly illegal, as the same diminishes the competitive edge of the candidates. Stop. Prayer has been made to provide 2 marks to those questions which were found to be proper at the preliminary stage, but later got changed during publication of the final answer key. Step. According to the petitioners, the commission ought to have acted in accordance with Rule 11 within bracket VI of the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes, third bracket open, except work education and physical education, third bracket close, comma, classes 9 and 10 and classes 11 and 12, bracket close, rules, comma, 2025. Wherein it has been mentioned that the expert committee shall deal with the suggestions / objections, comma, if any, comma, received from any applicants. The petitioners contend that the objections that they raised were not dealt with by the expert committee at all. Stop. Had their objections been dealt with by the expert committee, the same would have been reflected in the report filed by the commission. Paragraph. The commission opposes the submission and prayer of the petitioners. Stop. It has been submitted that all the objections which were raised, objections / suggestions, were duly considered, and the expert found and the expert made changes in respect of 10 questions. Stop. Rest of the questions which were referred remained unchanged. From the report forwarded by the commission, it appears that out of 60 questions, in the written test, at least 29 were objected to. Stop. Out of the 29 objections, 10 questions. Now, 10 answers were changed. Stop. Rest of the answers remained unchanged. Stop. Paragraph. It has been argued that as per the rules mentioned herein above, the decision of the expert committee shall be accepted by the Central Commission, and the same is binding upon all, including all applicants. Stop. It has been submitted that the court, not being an expert body, ought not to interfere with the answers provided by the expert committee. Stop. Paragraph. The prayer has been made not to interfere in the instant writ petition. Stop. Paragraph. I have heard the submissions made on behalf of both the parties and have considered the materials placed before the court. Stop. Admittedly, it appears that the questions which were framed by the questions which were it appears that that out of the 60 questions which an examinee was required to answer in the written examination, there are as many as 5 questions which have 2 correct answers. Stop. It is seen that answer that marks on attempt and marks to all were given. Now, marks to attempt were given in respect of two questions, and marks to all were given in respect of 2 other questions. Stop. The expert committee engaged by the commission found difference, not found difference, it have differed with as many as 10 answers published in the preliminary model answer key. Stop. The when a competitive examination is being held with lakhs of examinees, the authority ought to have ensured that the questions are framed in such a manner that the scope of objection remains minimal. Stop. The report of the commission suggests that as many as 1923 objections were raised in respect of one question, 1402 objections in respect of other, and several objections raised in respect of couple of other questions. Stop. paragraph. When the deciding factor in making to the preliminary list is 1 marks or even less, comma, the authorities should have taken care to prepare the question paper in such a manner that the same remains error free to the extent possible. Stop. True it is that the court, not being an expert, comma, usually do not enter into the domain of the correctness of the questions or the answers provided by the experts. Stop. The rules clearly lay down that the decision of the committee, expert committee, is to be accepted by the Central Commission and is accepted, not is, will be accepted, not will, shall be accepted by the Commission, and the same shall be binding upon all the applicants. Stop. Paragraph. It appears that the Commission has checked the answer scripts of the, not answer scripts, OMRs of the examinees in a standardized manner, and there is nothing on record to suggest that the petitioners were discriminated against the others. Stop. At this stage, no, not at this stage, in such a situation, the court is not inclined to exercise jurisdiction in the matter, as the same may have a rippling effect on the other examinees also. Stop. Next. In view of the above, the writ petition fails and is hereby dismissed. Stop. এই last line টা লেখার আগে আর একটা line লিখুন তো। The petitioners, while appearing in the examination, were aware of the manner in which the the OMR sheets of the examinees would be corrected. Stop. The petitioners were aware of the provision of the expert committee in deciding in dealing with the suggestions / objections. Stop. The petitioners were also aware that the decision of the expert committee shall be binding upon them. ঠিক আছে? এবার ওখানে under in view of the above, the court is not inclined to exercise jurisdiction.
The identical matter, Lordship, was sent for revisiting the question by the committee.
It's now no further
Similar
revisiting. Maybe similar, but then as time is advancing,
I understand.
and we are coming close to the last date
I had
prescribed
come
by the
much prior, my
Supreme
lord.
Court.
I had come
The
much prior.
court is not
No, I
going
understand.
into all this.
My lord, I have challenged the decision-making process. I am not challenging the decision. My lord, in the similar matter, Your Lordship passed another order, and I had not come at the latest stage. I had come much prior to that. Now, kindly appreciate, kindly send it
No,
for
I'm
revisiting.
sorry, I'm
Yes.
not going to change anything.
Kindly send it
Whatever
for
has been passed there is there.
very well, my lord. Kindly send it for revisiting the.
No, sorry.
Your Lordship had passed this order.
And maybe I say I will not go back there. It was passed at that point of time.
No, it is not much left. My lord, this is of 4th of December.
Call the next matter, please.
Kindly records my submission on that. My lord, I'm
No,
submitting.
sorry.
Kindly records my submission. On
I have not recorded the decisions referred to by the commission.
that, because that is not applicable.
I am not referring
Your
to this
Lordship, the
also.
order I'm referring to, my lord. Myself.
Yes, call the next matter, please.
Grateful to Your Lordship.
Yes.
Petition. Lordship, on the last occasion, I was submitting that say, this is a matter in connection similar to that Somnath Pramanik matter in which the scheduled caste candidates have been published as.
There's an appeal.
candidates.
There's an appeal, my lord, pending before the Honorable Division. Oh, Mr. Boss, sorry.
Lordship, there was a question, my lord, that fell from the bench that here in the application form, it was written general. I have taken instructions in this matter that when the printout was taken, while the filling up the application form, that time nothing was being shown. I have prepared, my lord, a supplementary affidavit to this in this regard. There, my lord, just like the other matters, it was shown blank. Now, after the subsequent notifications came that in respect of OBC, you will have to fill later on, this was done. As we all know, in respect of that, in the final notification, it was said that unless you fill up the forms, you will be considered as general. The application form that has been annexed to the writ application, that printout was taken after the final notification in the month of August. So, my lord, my humble submission is that I am covered by the Lordship's judgment in the Somnath Pramanik.
This appeal which they have carried will be taken possibly tomorrow, taken up for consideration. I've fixed one matter day after tomorrow. Let this also appear. In the meantime, you serve the supplementary.
In fact, that appeal was there. It was in my case. That is C.
Yes.
So SSC, they sought an adjournment tomorrow.
They sought an adjournment.
Yes.
It was submitted.
No.
You sought an adjournment.
No. One day I sought an adjournment. Thereafter 2 days have been sought.
That I had no scope. I said I am already arguing. So tomorrow it will be there.
So that is the reason I'll place it on Friday.
Lordship,
Please come.
keep it.
Supplementary affidavit filed on behalf of the petitioner in court today is taken on record. Copy served.
Lord, I am serving it.
Please do. Let copy of the same be served upon the learned advocate representing the respondent. Released Friday.
Number 7, my lord, I appear for the petition.
Polanraj.
Lord, in this matter, my lord, petitioner is praying for, my lord, to publish the entire list with full details for all the candidates who are not specifically found to be tainted and who do not fall under the purview of any unlawful appointments obtained through rank jump, out of panel, expiry of panel, or any other category. The 4 broad categories, my lord, which the Supreme Court has mentioned. And other than the 4 broad categories, my lord, I have specifically.
This is in respect of which?
This is in respect of class 9-10.
9-10.
Item 7 is for 9-10 and item 9 is for 11-12. Both are same, having the same prayer.
All right.
My lord, just I want to place one thing, my lord. Pursuant to order dated 26th of November 2025, the Honorable Supreme Court, my lord, it's at page 122.
Yes.
My lord, page 122, my lord, just I read out the relevant portion. The High Court shall, my lord, this is the first, second, third, fourth paragraph.
Yes.
The High Court shall, however, ensure that none of the tainted candidates are permitted to slip through in the fresh selections, be it on any pretext. Pretext. The High Court shall also ensure that the list of tainted candidates is placed in the public domain with full details so as to ensure that this does not happen. Well, these are the 2 directions. And my lord, in order to ensure that, my lord, the tainted candidates are not slipped through, my lord, I have prayed before your lordship that a list of candidates who are not specifically found to be tainted. Supreme Court has, in the judgment, my lord, has categorized two types of candidates. One is, your lordship knows, my lord, one is tainted and one is not specifically found to be tainted. I have annexed the order also. So these lists may be public, excluding all. Thereafter, my lord, whatever happens, my lord, that's a different issue altogether. My lord, there are other prayers also for publication of OMR, for not allowing the tainted candidate to sit for the examination for
I've already passed an order in one of the matters.
Yes,
The
my lord, your
direction
lordship has
given.
passed in respect of Group C, Group D.
All right. But then, has that been appealed again?
No, there is no appeal before the division bench. There is one SLP filed, my lord. Your lordship would find, my lord, it is still under defect.
All right.
There is not even a stay, but it has been filed by the School Service Commission, as well as yesterday I came to know state has also filed an SLP against that order. But my lord, your lordship may pass order in this one also, because we will also participate in the proceeding before the Supreme Court. Because there, as of now, there is no stay and it is still under defect. And my lord, I just want to show, my lord, why I am praying for segregating the persons, those who are. No. Why I am praying for segregating the persons, those who are after expiry of panel. Your lordship would come to, my lord, page number 105. That's the notification of the commission.
Yes.
My lord, publication of final panel in respect of the selected candidates and final waiting list with reference to first state level selection 2016 for recruitment. This notification was published. My lord,
105, 12th March 2018.
yes, my lord. This was the date on which the notification was public. So 1 year after that is, my lord, 11/3/2019. Any appointment made after 11/3/2019.
Was this extended, this date?
No.
There was one chart
no,
shown to
my lord, in respect of class, in respect of Group C, Group D, there is a provision in the rules. I brought the rules for extension. In respect of class 9, 10 and 11, 12, there was no provision for extension. My lord, kindly see the rule once. This was previous SLST rules. 2016 rules. Para 15, clause 15. Each panel and wait list shall remain valid for 1 year from the date of publication of the panel and waiting list, comma, or the date of advertisement for the next selection test, whichever is earlier. And my lord, paragraph 31 of the Supreme Court's judgment, the main judgment, my lord, it has categorically stated, my lord, paragraph 31, that is at page 69. WBSSC, paragraph 31, may I just read out? WBSSC has also tried to justify the extension of the term of panel. As noted above, the time period of 1 year specified in Rule 21 for destruction of OMR sheets coincides with the time period specified for the validity of panel. There is no doubt that the counseling process and appointments were made to the post of assistant teachers for classes 9 and 10, 11 and 12 were made after expiry of panel. This is illegal and contrary to rules. Reliance on the orders, judgments of High Court in stray of cases of rank jumping where the High Court directed to appoint the candidates after expiry and validity of panel would not have any significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment procedure and had not specifically examined the question of appointment after expiry of panel. At that point of time, my lord, court was passing order. Subsequently, the court came to know, High Court came to know that these appointments are being made after expiry of panel. Thereafter, the entire scam of SSC came into picture. That has been categorically recorded and order has been passed. So, my lord, at this stage, my lord, I want that the list of candidates, those who are not specifically found to be tainted, my lord, that may be published. Paragraph 20. My prayer, my lord, kindly see, my lord, prayer B. Other prayers, my lord, as an interim prayer, page 28. A writ in the nature of mandamus commanding the respondents and each one of them to forthwith publish the entire list with full details of all
আর ভিডিওটা দেখ কি হচ্ছে কোড দেখাচ্ছে না কোড কোথায় তোর রিদ্ধি জয়েন্টকে দেখাচ্ছে সাউন্ড কই সাউন্ড আছে কই আমি আমারটা বের করছি আরে কোটের মধ্যে তো ঢুকতে পারছি না কি আমি তো বুঝতেই পারছি না
Sir, I believe the code was disconnected.
Yes. We have been disconnected.
No, I think that it's from the court's end, since all of us are still present in the meeting. And even on the live stream, I can see it is just us. I think it's on the court's end.
কোর্ট থেকে গেছে জিজ্ঞেস করো।
হ্যালো ভার্চুয়ালি কোর্টে কোর্টে প্রবলেম হচ্ছে, একটু পাসওয়ার্ড তাহলে বলতে বলুন কি করা যাবে। ভিডিও কলে কি করে বন্ধ হবে? ভিডিও কল মানে কি হোয়াটসঅ্যাপে ভিডিও কল করে দেখাবে তুমি? জজকে বলো পাসওয়ার্ড করতে, আমাদের তো দোষ না। বিষ্ণুদা ফোন করছে, সাদা নম্বর ওইসব রিপোর্ট নিকাদের কাছে আছে, এই করে জেরক্স টাইপ প্রিন্ট করে নাও। বিষ্ণুদা ফোন করছে, ভিডিও কল করছে।
হ্যালো
সরি জজ স্যার শুনতে চাইছেন। আপনি বলুন আপনার বলুন।
My lord, I am very sorry that all of a sudden it has been disconnected. Now, my lord, kindly come to the order which has been page 121, starts from page 21. Kindly come to, my lord, page 122, which has been read. The High Court shall, however, ensure that none of the tainted candidates are permitted to slip through in the phase selections, be it on any pretext. The High Court shall also ensure that the list of tainted candidates is placed on the public domain with full details as to ensure that this does not happen. This tainted list has been placed in the public domain. We have placed it. 27 November. So far, the untainted as concerned, now those who are not specifically tainted, they are working. That is also we have prepared in one matter. Your Lordship has directed, we will give it. Now we will give it. Now, therefore, this list, what has been stated in paragraph, this judgment of 46, the judgment paragraph 46 is concerned. Kindly come to, my lord, page 72. The last question relates to the relief granted and whether it requires any modification. We find no valid ground or reason to be interfere with the directions of the High Court that the service of the tainted candidates were appointed must be terminated and they should be required to refund any salaries payment received. Since their appointments were to be removed, so and so, the next paragraph. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void, but due to the egregious violation and illegalities which violates Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. However, candidates who have already employed need not to be asked to refund. Then categories have been said. Then, my lord, kindly come to paragraph. Appointment. Now, the appointments have been with the untainted one. They kindly come to paragraph page 76. Kindly come to page. No. I kindly come to page. An advertisement for recruitment to the aforesaid post shall be published before 31. First, kindly see the first. We are inclined to accept the prayer made in the present application so far it relates to assistant teacher for classes 9 and 10 and classes 11 and 12 not found to be tainted, subject to the following condition. What are the conditions? Shall be published before 31st March 2021. the examination and the entire recruitment process shall be completed by 31st December 2025. And the state government, the applicant, West Bengal Board of and the West Bengal School Council shall file their respective affidavits by 30th. It has been done. In case so and so, we clarify the orders shall not be read as a conferring any special right or advantage to the aforesaid teachers. Aforesaid teachers means untainted teachers. And insofar as the phrase recruitment process is concerned, we are not inclined to accept the prayer in the present as insofar as non-teaching posts in group C and D are concerned, as the number of appropriate appointees specifically found to be tainted in the said group is substantively high. And secondly, what has prompted us to pass the order in respect of assistant teacher not found to be tainted is that students undergoing study presently should not suffer on account. Our tainted list is also there. Repeatedly it is coming, they are approaching, publish this, publish this, publish this. What is the legal right they are having? They have already participated in the selection process. Must be again having been failed. They are
No,
approaching.
past.
Past and
Call for verification.
call for verification, very good. Call for verification, very good.
Again, I am also having a stigma.
The
The selection process, tainted candidates are allowed.
will you allow me to speak or not to speak?
No, sir.
Only you will speak.
No, you
we will not speak. You are only speak.
No, you have stated that I have failed.
No,
I have
that
passed
is
out.
the objection has to be
that have.
My lord, your lordships on the other day said not to speak any other persons. Now, if I say anything, your lordships will pass comments against me. Now, how they are dealing with these matters? Now, my lord, our submission is very clear that tainted teachers list has been published. Untainted are working. The what list I will pass me not found to be tainted. Again, one after another prayer is being made. My lord, one thing, my lord, kindly excuse me, my lord. I want to communicate one thing to your lordships, my lord. Whatever it may be, 2000 selection process, those who will go, their name have been deleted, the Supreme Court ultimately has finalized it. If they found that any tainted person has been appointed by me, they will come, of course. But through the court, they cannot make any roving inquiry. I cannot satisfy everyone's demand. Every day, everyone will come, every day demands. I am, whether I will do my selection process or I will do it, I have to go by the selection process. Time has fixed up to 31st December. So far the teachers are concerned. We are working in tremendous pressure. And all have been, my lord, whatever your lordships have directed, we have uploaded. Uploaded already. Only one matter that your lordship, with my deep respect to your lordships, that your lordships have extended the scope of the candidates. That way we have filed an SLP. But kindly do not entertain now. If anyone, if you wants to entertain, if whatever it may be, let all that after the selection process is completed. If selection anybody has got wrongly, and if it has been established, his name will go. Thereafter, whose name will come, that's we do not know. I will be beseeching to your lordships kindly, do not interfere at this stage now. And your lordships are not interfering in number of matters. A number of matters that I am grateful to your lordships. But the allegation regarding recommendation after the third round of counseling post-expiry of the panel in that matter are misplaced. Because it was first the recommendation process was delayed due to legal so and so. And second, my lord, the main submission would be, who would be tainted has been said by the Supreme Court itself. And who are untainted, that has been said by the Supreme Court also. The waitlisted candidates of 2016 who didn't get the chance, they cannot make a road and path in this selection process by saying so. It is only their case is that 2016, Those waitlisted, those who have not been recommended, waitlisted or not recommended, they should be treated as an untainted. Lord, that is not the scope of the Supreme Court judgment. With great respect, I tell you, Lord. And Lord, kindly do not Lord, pass any directions we have given. Let them go, see, watch everything. And those who are working, those who are working up to 31st December, they will be treated as untainted.
Please come.
My lord,
These are I
there
am
are
so
also
grateful,
other prayers, but as an interim
Lord,
measure,
I
my
am
lord,
so
I am
grateful.
praying this. Because in this prayer, my lord, no one will be prejudiced as of stage, and the sanctity of the examination instill confidence among public. Because again, my lord, but why did the Supreme Court pass such type of orders? Because they were a tainted candidates, they were allowing.
Good question.
Lord, here no case of fraud has been made out now.
Maybe as an interim
No,
measure.
no. But not to satisfy public confidence is in different concept, not here.
Yes, tainted candidate was allowed. That is why
Public
the
confidence is a different question.
Candidates list has been
To the second SLST within bracket 80, 2025 in respect of classes 9 and 10. Stop. The petitioners have participated in the recruitment process. Stop. They pray for a direction upon the commission for publishing
it's 28.
the entire list of candidates with full details who have not been found to be specifically tainted in the public domain. Stop. Submission of the petitioners is that the same is required to be published. For proper implementation of the order passed by the Honorable Supreme Court on 26th November 2025. In a special leave petition within bracket civil, diary number 46049/2025. In the matter of Bibek Paria and others versus the state of West Bengal and others. Step. It has been submitted that the Honorable Supreme Court was pleased to direct the High Court to ensure, not direct, observe, that the High Court shall ensure that none of the tainted candidates are permitted to slip through in the fresh selections, be it on any pretext. Stop. Paragraph. Attention of the court has been drawn to the judgment passed by the Honorable Supreme Court on 3rd April 2025 in Civil Appeal number 4800 of 2024 in the matter of State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. Reported in 2025 SCC Online SC 719. Paragraph 31. Wherein the Honorable Supreme Court specifically held that the counseling process and the appointments made to the post of assistant teachers for classes 9, 10 and 11, 12. After expiry of the panel is illegal and contrary to the rules. It has been submitted that the list of tainted candidates published by the Commission does not contain the names of candidates who were called for counseling and given appointment after the expiry of the panel. Stop. The list of tainted candidates only consists the names of candidates in respect of whom there is issue with regard to the OMR, rank jumping, out of panel appointment, only these three heads or any other head?
No, these three heads, they have public expiry, they have not public.
William, sentence. And, and out of panel appointment. Step. It has been submitted that the that as per the order of the Honorable Supreme Court, the candidates who were called for counseling and provided appointment after the expiry of the panel ought to be treated as tainted candidates, and their names should also be published and be brought to the public domain. Step. Apart from the above, there are other prayers of the petitioner. Step. The prayer for publication of the list of the untainted and specifically not tainted candidates is only an interim relief which the petitioners are praying. The paragraph. The aforesaid submission and prayer of the petitioners is opposed by the Commission. Stop. It has been submitted. আমি সব জায়গায় petitioners বলেছি, it will be petitioner action. It has been submitted that the Commission, in compliance of the direction passed by the court, has already published the list of tainted candidates. There is no direction upon the Commission for publication of the list of untainted or not specifically tainted candidates. The petitioner cannot be permitted to convince the court to go for a, to conduct a roving inquiry contrary to the direction passed by the Honorable Supreme Court. Stop. The Um, according to the Commission, all directions for publication have been acted upon. Stop. It has been submitted that the candidates who are still in service have to be taken as untainted candidates. Stuff. Paragraph. I have heard the submission made on behalf of both the parties. Yeah. The Supreme Court time and again has made the stand extremely clear that none of the tainted candidates are permitted to slip through in the fresh selections, comma, be it on any pretext. The Honorable Supreme Court specifically held that the counseling process and the appointments made to the post of assistant teachers for classes 9 and 10 and 11 and 12 after the expiry of the panel is illegal and contrary to the rules. Stop. It has been brought to the notice of the court that the panel in question was published by the West Bengal Central School Service Commission. কি বললাম? That the final panel in respect of selected candidates with reference to first SLST-2016 for recruitment of assistant teachers in classes 9 and 10 was published by the Commission with a notification dated 12th March 2018. Stop. The West Bengal School Service Commission, bracket open, selection for appointment to the posts of teachers for classes 9 and 10 in secondary and higher secondary schools, bracket close, rules, comma 2016 has been placed before the court. Stop. Rule 15 of the 2016 rules specifying the validity of the panel and the waiting list has been relied upon. Stop. The same mentions that each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next selection test, whichever is earlier. It has not been brought to the notice of no order, comma, notification or any contemporaneous document has been placed before this court in support of the submission to prove that the validity of the panel stood extended beyond the statutory time period. Stop. In such a situation, the date of expiry of the final panel published by the Commission has to be taken as 11th or 12th March 2019. Stop. Any counseling or appointment given to the candidates in respect of classes 9 and 10 and 11 and 12.
Well,
Now,
11, 12
11,
date is
12
different.
দিতে হবে না। 9 and 10 would be beyond the statutory time limit. Stop. The Supreme Court has consciously used the expression within quotes, be it on any pretext, in the order dated 26th of November 2025. The same, comma, not same, the aforesaid expression, comma, in the opinion of the court would certainly include the candidates who, according to the Supreme Court, were given illegal appointments beyond the expiry of the panel. Stop. The Commission, comma, for reasons best known, comma, did not publish the names of those candidates who were directed to appear for counseling and provided appointment beyond the expiry of the panel. Stop. For complying the direction passed by the Honorable Supreme Court, comma, the Commission has to ensure that the selection process that is being conducted in accordance with the judgment passed by the Honorable Supreme Court remains absolutely corruption-free, comma, transparent, and fair. Stop. Till the list of tainted candidates is not properly prepared and published, comma, it will not be possible for the Commission or the contesting candidates as to who may be treated as the untainted or the specifically not tainted ones. Stop. In line with the judgment passed by the Honorable Supreme Court, the Commission ought to publish a proper list including all heads which the Supreme Court found to be illegal. Stop. Next. If the Commission is not willing to publish such a list of tainted candidates, then it has to be assumed that anybody whose name is not anybody whose name does not feature in the list of tainted candidates has to be taken as an untainted or not specifically tainted one. In such a situation, there is high possibility that the candidates who were provided the opportunity of counseling and issued appointment letter beyond the statutory time period may slip through. And the same may pollute the entire selection process all over again. Stuff. The candidature of such candidates may again be challenged before the court of law, leading to uncertainty in the selection process. It is the earlier selection process which was initiated in the year 2016 stood set aside by the order passed by the Honorable Division Bench of this court in the year 2024, and the same has been upheld by the Honorable Supreme Court with certain modifications in the year 2025. The candidature of the candidates ought not to be put under jeopardy on repeated occasions. Stuff. After all, the job would be the source of life and livelihood of the candidates who may be selected in the ongoing recruitment process. Stop. Next. In view of the above, the interim relief sought for by the petitioner stands allowed. Stop. The Commission is directed to publish a proper list of tainted candidates containing all heads which were found by the Honorable Supreme Court as illegal. Stuff. The Matter is made returnable once again
My lord,
on. Yes, please.
not specifically found to be tainted, that list.
Kindly seize the interim relief prayer.
It's there.
31, page 31.
Yes.
An order directing the respondent concerned to forthwith publish the entire list with full details of all candidates who are not specifically found to be tainted and who do not fall under the purview of any unlawful appointment obtained through rank jump.
A separate list including names of the candidates who have been found to be untainted or not specifically tainted shall also be published,
But excluding those categories.
so that the candidates, so that such candidates may be saved from the stigma which they are currently facing in public. Yes, the matter is made returnable on 8th of January 2026.
My lord, just kindly specify that a list of candidates who are not specifically found to be tainted other than those 4 categories.
I have kept one category in the list of tainted candidates, which means the other becomes minus that.
Well, and kindly frame a time limit that they should publish within 1 week or so.
Forthwith publication.
Since your lordship has hold that March 2019 is the cut-off date for expiry of panel, my lord, in item
The affidavit
number
of service be kept with the record.
This was the subject matter in item number 41, your lordship last stock is
Item number 41, my
we
lord,
have
we have
filed
taken
also,
some
my lord.
orders of High Court, my lord, where.
Well, item number 9 is class 11.
1 minute.
Well, this has to be, my lord, adjudicated because item number 41, my lord, we have made a CAN application. My lord,
1 minute, this is item 7 going on. It will be called on one by one. Whatever you've got to say, you please say at that point of time.
Since your lordship has already
hold, my lord.
The cut-off, my lord, our point in item number 41 is that it has been extended, my lord. Because before the Supreme Court also, my lord, the commission has filed a report saying that it has been extended and that has been not been discarded by the Supreme Court.
Very well.
I have
My lord, my lady, I'm also appearing in items 18 and 41.
There is nothing on record in this matter shown for extension. The commission could have shown that this has been extended. The commission has not shown it. The commission is the best person to show that the date has been extended. The commission has not shown.
It is not the commission, my lord. It is also, my lord, our candidature. Your lordship kindly appreciate, my lord.
I understand your
One line of
candidature.
permission without hearing us, my lord, may cause, my lord.
I understand.
Kindly
When
appreciate
your submission is to be supported by the commission till I get it from the commission that it has been extended. I cannot take it.
The commission is not ready today, my lord. Item 41 commission.
No, no, we can
My lord, item 18, the commission's affidavit is there. It's been filed in the CAN.
Mr. Bandyopadhyay is making some.
We can file affidavit.
Yes, there is an extension.
Mr. Bandyopadhyay is making.
We can file affidavit, it has been extended. But your lordships have not given us.
Bhai, Mr. Sir is making a statement, please.
We can file an affidavit. We can show to your lordship extend. No, extend. Your lordships is passing a final order. Is a final order without giving chances to file affidavit.
All right. Direction the link for filing affidavit in opposition.
No, prior to that, how can I implement it?
Application is pending.
All right.
41 item number, my lord.
All right.
One matter I have shown to your lordships.
Affidavit in opposition.
No, it is very difficult to argue a case without filing our affidavit.
23rd of December.
Only on the basis of the petitioner's submission statements. We have to file our affidavits. Your lordship, final order. Having a cascading effect.
And take on one more line. The candidature of the candidates relying on the list published, if they participate in the fresh selection process, shall abide by the result of the writ petition.
But I have a very humble prayer, if you lordship
Yes.
kindly consider that Lordship is Lordship was hearing and has been hearing, and next date in 6th, wherein, my lord, this particular point, whether after expiry of panel all candidates they become tainted or not, Lordship has heard also.
No, but then paragraph 31 of the Supreme Court judgment is very
Well,
clear.
paragraph 31.
I cannot
But
go.
my lady, may I just request this? My lady, may I just request this? I'm sorry, I'm appearing virtually.
Just 1
My
minute.
lady, may please hear us in items 18 and 41 on this point, and just please consider our arguments before passing an order.
All right.
May I,
This is all we're requesting,
very
because
humble
there is whether this is an irregular appointment or it is tainted or untainted. That's the legal argument.
But then how can this court decide if the Supreme Court has already decided it?
No, my lady, respectfully, the Supreme Court does not consider those whose panels.
Dr. Guruswamy, just give me one.
Why don't you satisfy the court?
No, my lady, even the Supreme Court's order does not consider these people to
No
be
contrary
tainted.
objection. Supreme Court has held it to be illegal.
No, my lady.
Illegal but not tainted.
paragraph.
Illegal but not tainted.
May I just read?
Illegal but not tainted. Supreme Court has said that illegal but not tainted.
Can you give me just 1 second?
Similarly, other
I have a
candidates who are
very
not
humble prayer in
specifically
this.
tainted. That is the language of the Supreme Court, not specifically
Dr.
tainted.
Guruswamy, just give me 1 second. Just 1 second.
Please, my lady, please just hear us at some modicum of with some
You
time
are not a
before
party
you
at
pass
least.
this order.
Dr. Guruswamy, just give me 1 second. Just 1 second.
Applications are being
very
moved
humble-
against the persons.
humble-
They have not been made
I'm
party.
not to say why should you be
In this order, no one will be prejudiced as of now.
Everyone will be prejudiced.
No one will be prejudiced.
Everyone
sir.
will be prejudiced.
No one will be prejudiced.
Everyone
The
will
list
be
is published.
prejudiced.
No one, you have a right to challenge the list also.
No, everyone will be prejudiced. You have right to challenge and also made party.
Then I'm not going to sign it now.
My lord, this only one sentence, my lord. My lord, Lordship has been hearing this point. We may lose. I'm not saying that whatever interpretations that we are saying
Is
but-
correct.
Yes, but one thing for sure, if the Honorable Supreme Court has said that the panel expiry is tainted, we will not even say a single word. But if the situation is this, that the Honorable Supreme Court held that tainted are those persons who are in that chart, which I have read out and Lordship has all taken note of, then, my lord, this order may have a devastating effect. My only prayer is, my lord, kindly keep it on
It
6th.
will be taken up. It will be taken up now after we are already in during the recess period.
Yes, grateful.
Lord, item number
Grateful.
12, item number 9.
Orders, I am told there are orders of court. Please bring if you have any.
Yes,
And
yes.
the commission has any. Please show. If you have any, please show.
My
That
we'll show the Supreme
there
Court
in my
order.
oppositions,
Period.
but I say different. I say that there are total out of 8 counseling, 7 have been found to be in order.
No, my lord,
Wait.
Supreme Court, yes, Supreme Court found that beyond 2, all are illegal.
Yes.
I don't say it is legal. I say these two things are
Your expression is even though it is illegal, they cannot be termed as tainted.
not, they cannot be. Supreme Court did not term them as tainted.
Yes.
I'm not saying it's not my interpretation. I say the
Right.
Supreme Court categorically said that those who are tainted, they are the persons of OMR mismatch and
Like the other three
that's-
categories.
that is only thing.
The out of
And-
expiry
And as far
beyond
as the
expiry.
expiry,
That
that's
is not-
that's of course illegal. For the illegality, you lose the job. That for institutional illegality, you lose the job, but that is not the cheating. That is not the fraud. That is
Yes,
not.
yes.
May I just
something
make
remember
one?
it. I remember
Yes,
it.
may I
Oh,
just-
all I
may I
humble, all I pray this.
My lady, may I just further
Lordship has
amplify
dictated
this?
it, kindly do not sign it.
I am not signing it. I am keeping
Yes,
it here.
yes.
I'll hear you
Because
and
it
then
has either way.
Yes,
my lord.
and may I just read
Not
one
say-
line to you
will
from
not
the
say
Supreme Court's language to explain this, because I have the judgment in front of
Our
me.
interpretation. I say that if whatever would be there, it has to be what Supreme Court said.
yes.
If Supreme Court had said this, we will accept it.
Yes. My lady, may I just read the language of the Supreme Court, just
Next matter,
specifically,
Milord,
just
will be
three
taken
words.
up on Friday.
Then your lordship
Item number
Other
8.
candidates who are not
What
specifically
is the
tainted.
This is a similar matter.
Madam,
Correct,
item
correct.
41, then kindly take up.
18 and 41. 41, if my lady will hear, we will argue this and take your ladyship through the Supreme
9,
Court's order.
I'll take up later on.
9
It
is
is the same thing.
same thing, 11,
There
12,
is some
835.
issues with them. If two orders of the same bench becomes contradictory, then it will be difficult. So for
Yes.
maintaining parity, I'll hear that also, and then I'm going to sign or not sign or change and
Yes.
modify
Very
whatever.
well.
9 will be heard
Grateful.
along with 18 and 41.
Grateful. Grateful.
9, because
9 is regarding
11,
11,
12.
12.
11, 12.
yes, 7, item number 7, my lord has been pleased to pass an order. No, your lordship has been inclined not to sign it
Right.
without hearing.
This is 9 and 10.
Class 9, 10, yes.
This is
7 is class 9 and 10, and 9 is 11 and 12.
11, 12 I'm not touching now. 9 and 10.
Very well.
Item 8.
So your lordship will only, my lord, hear after lunch, my lord.
41 it is being submitted.
18
lordship
and
will hear
41 is
first.
on and out of panel. 18 and 41, my lady.
9
Expiry
and
of panel.
9 and 10.
9 and 10, 11, 12, both, my lord. 18. Even there's someone-
আরে 41 এ তো অর্ডার হয়েছে 41 এ তো অর্ডার
অর্ডার
হয়েছে
হয়েছে বলতে বলেছি তো আজকে
18,
Let
41,
us see
19.
41 what happens.
My lord,
Yes,
41
yes.
is okay now.
along with item
41
number 7.
41 is out of panel. That's what it deals with, out of panel.
Plus at
2 p.m.
41
let that matter
Expiry
be
of panel.
item
Yes,
7 also with
41
the panel. All 19 matters.
41 টা প্রথমে হবে
may be taken up.
Has come regarding
But,
Toady Harness matter. Toady Harness, item number 17. He will leave the court, other side is here. Your lordship is already going to pass an order. Then your lordship asks the other side to bring the updated notification. And we are covered by your lordship's order that we have. Page annexed at P7. Toady Harness, your lordship already passed the order.
No, but then see, matters are being called serially. How can I just jump and
Other side is
call?
here, my lord.
Other side is there in so many matters.
My lord, item 41 may be taken up now.
41.
My lords, if may it please, my lady.
I will submit regarding the
Tomorrow,
orders
tomorrow-
passed by the Supreme Court.
Well, then tomorrow kindly fix a time. I will
Item 41, but two things I will submit because many of them have come regarding the orders passed by the Supreme Court and the division.
I didn't follow.
Item number 7, my lord, two things I will submit, my lord,
Uh-huh.
regarding the orders passed by the division bench and the Supreme Court.
That you whatever you have submitted is submitted. You want to add something
Add
else?
something because many of them are now coming to
Yes.
make submissions. My lord, two
All
things.
right.
Well, I have this submission. Lordship,
Not today, my lord.
if
My lord,
Lordship,
may I
Lordship,
just start in item 41 on this panel issue?
well, if Lordship may kindly consider this.
My lord,
17 are there, I can see. 17 applications.
yes, my lord.
Can 1 is mine, my lord.
My lord, of which, my lord, can 12 to 17 and can 3 have not been served, so I do not know what are.
No, can see I have some.
No, fine.
ওইটা ওখানে ভুল করে হয়ে গেছে।
My lord, can 8 in item 41?
Well, my submission was only this, that there are several matters. Now, out of the several matter, this is the main common issue, that after expiry of panel, are they tainted, or whether illegality automatically means tainted or not. Now, Lordship is hearing the substantially the other matter. And only for the
41.
no other matter means yesterday
is-
that matter where this point was taken by
Also
Mr.
there.
Yes. It what
Not,
please?
not
For-
specifically.
It was specifically there, and Mr. Bikash Bhattacharya, he has made elaborate submission on that, and that is the reason, Malad, we were responding to that.
Item number 19.
Now, in any case, all I say, Malad, there has to be either whatever the OS, Lordship will take a final, which will be applicable for everyone. It is not piecemeal.
If my lady
But
will therefore start with 41, which
one
speaks to
consistent view
specifically this
comes.
issue.
Yes, yes.
For that purpose,
Yes.
Lordship has fixed all other matters on 6th.
Yes.
I was only requesting. There are two. I will be saying two things. My first request before Lordship is, if Lordship also take all this with 6. Now,
My lord, I have my
no,
objections here.
allow me to finish. This is
In item 41, there is already
Because-
option for production of the
there is no difficulty, because Lordship kindly remember when this was done. I was sitting, I intervened, I said that there is a possibility that I might be able to persuade your Lordship that illegality does not mean tainted. Illegality is one thing, lose the job, but tainted is different thing. Lordship accepted that, and that's the reason change from publication to producing before Lordships. Productions, I am absolutely fine. All I am praying this, kindly keep, my lord, because this would be a consistent view. Whatever happens, my lord, it should happen to every. Whatever happens,
And the-
my lord, on this point, this will happen, my lord, for every matter. Not that in one matter, one directions, another matter, another directions.
And
On particular this
urgency
point.
of hearing this issue as to whether being out of panel
pass
is
beautiful, my lord.
only
First, my lord,
irregular
we will complete the
but
point.
not tainted is
In my lord,
because my
Supreme
lady
Court
has
order, my lord,
dictated
in
the order.
Vivek Paria, jana bole di. My lord, kindly take
So
the
if
Vivek
my
Paria's order.
lady could just start with item 41, since the order has been dictated on this issue.
Hearing the matter 41. Let it be.
No.
41 ta.
Abide by that was already there. Production before your lordship is already there. All I'm saying that.
All right, 41, who's for the
My lord, before that, my lord, may I
My
indicate
lord,
one
I
thing?
appear in 41.
Vivek Paria
I
matter,
appear
my
in-
lord, where Supreme Court specifically stated, my lord, I just read it, my lord. We are informed that a writ petition being WPA number 26288 of 2025 has been entertained by a learned judge, the High Court at
Calcutta and issue were flagged. So that matter is item number 19, my lord. Where, my lord, first time, yes, no, my lord, Moshumi Mondal matter. And because Supreme Court says, because on that score, my lord, matter is remanded back, my lord. There were, my lord, several issues was involved. Why? First issue is that, my lord, tented.
Yes, I followed.
So, my lord, it is a kind enough, my lord, take up that matter. Until and unless, my lord, that matter is, my lord, taken up, my lord, that issue, because of that, my lord, issue, what issue involved therein? One is rank jump, another is out of the panel, third one is expiry of the panel, fourth one is tainted and untainted. Why? That is why, because of that, my lord, first time that came, my lord, 19 matter, because of that, my lord, till date, they, in pursuance of my lord's order, they not published that. So, my lord, kindly take up this two, my lord. So, because it is pursuance of Supreme Court order.
My lord, my lady, in pursuance of this issue on panels, may I just take you to para 31, which your ladyship was referring to?
Item 41, there was a direction for production of...
Yes.
Who are you?
My lord.
So what? There is a court order. What do you mean to say you are disputing?
No, you cannot dispute.
I am hearing the commission. Please wait.
Regarding production.
I hear you.
No,
as
that is
and
for
when the
production.
is taken up.
Production, no difficult.
Is the report of the commission ready?
My lord, yes, list is there. We have prepared a list, my lord, after the third council, although we are not saying it's an illegal. After the third council,
Commission
what are
ought to
the...
ensure to rule out the so that all right.
Where is the commission? Give her one.
Lordship, take the list, keep all the matters on 6th along with other
I have a
matters.
strong objection on third counseling.
Objection.
You are having all objection regarding appointment.
Mala, they want a piecemeal hearing. Lordship is already hearing in a very consistent manner all the matters. Where this is the
Or my lady may just fix
now, if the fundamental question is suddenly decided,
on
my lord,
panel,
in these matters in a motion,
which is what
then
41
we suffer a
pertains to.
lot.
My lord, why, with deepest of the way, why my learned senior friend is shying away from hearing this matter, my lord?
My lord, I am not shying away. I am not shying away.
My lord,
All I am saying that
not an admission
I am saying
motion.
that hearing is going on before your lordship.
Admission motion.
my lord,
But that was the issue. Lordship may check the YouTube, please. Otherwise, why did I make? I made submissions on this.
my lord, that is not the issue.
Paragraph 31 was placed before your lordship by Mr. Bhattacharya.
My lord, the issue which was being argued, my lord, before your lordship, which has been fixed on 6, relates to challenge to the rule, stage of granting 10 marks, and whether they have been 2016 appointees.
But that is one of the issues. That is not the sole issue.
Give me the list, please.
Yes, my lord.
No, I think we are here on the issue of panels. If my lady will just allow us to start in 41, that's the issue on panel. If I
Mr.
can just take you to...
Bandyopadhyay,
Yes,
there
yes,
is a direction.
yes.
In item number 41, the order dated 27th of November 2025.
Brother, we have prepared it. I don't know, any of my junior is not there. Let me just check it up, brother.
They are your juniors are here, but till you give a nod, they are not handing it over. You say
No,
yes.
I have said so. No. Brother, we are saying after, just after the third counseling, we are giving the list which your lordships wanted to see. We are giving it to your lordships. But we are saying this.
Nah, after the third counseling. Nah.
No, is it tainted or
and after the third counseling that we are not saying they are
after
tainted.
expiry.
And
from
by this
third counseling,
standard,
everything
we
is
will
tainted.
show to your lords, kindly excuse me, Milord. We will show to your lords after the third counseling how Mr. Samim has got an order to give an appointment to the others. I will show to you. There are other lawyers. There are other lawyers are there. All they have.
Shout. I do not know who has obtained order and what, because I was not there earlier, right?
I will show the order.
I just wanted to know, and that is the direction also, to produce the list of the candidates given appointment from classes 9, 10, 11 and 12 after expiry of the panel.
Yes.
This was the direction. A list has been placed before me. Does this contain the names of those candidates who have been given appointment after expiry of the panel?
Till, yes, yes. That is not,
এটা
they
থার্ড
were giving the
কাউন্সিলিং
appointments.
বলেছে
In terms of
Consider
2016,
expiry of the panel.
that panel was extended from time to time. This is their, my lord, this is their interpretation that the panel has been expired. Our interpretation is
as
that
per
this
rules they
panel has
cannot
not been expired. And we have said so. We have given the dates.
in
And
which
it's
order it has been accepted.
candidates who are
I have not been able to place my lord everybody.
candidates who are recommended after the third phase of counseling. Notice date, etc., etc. We have given it. Huh? Panel expired on 19 December 2019.
No, my lord, no, my lord, it can't be.
It is not a market that I will speak one thing and immediately you will speak. What you have learned from your senior?
Who is seeking for a copy? Who is seeking? If this is the order, then the court could have directed publication. That is not the order.
Yes.
The direction was only to produce before the court. It has been handed up. Let the court see why are you behaving. If you are aggrieved, you take it up. Orders are taken up to the Supreme Court directly.
Yes, that is.
You go there and challenge it.
This is the problems for which we have been suffering. Lordship, kindly take record by a judicial order.
Because of these tainted candidates, our candidatures are at stake.
But this
These are
is,
not
I
tainted
think,
candidates.
this
These are
should
not
not be
tainted.
said.
My lord,
Yes,
kindly,
even the Supreme
before
Court's
your lordship
language is
decides.
not specifically found to be
my lord,
tainted.
kindly make it this
Not.
way the hearing. My lord, kindly
Take-
first, my lord, Mr. Sudipto Dasgupta, Mr. Samim, or whoever they are, let them finish their argument. Then we will start our argument.
Let us
That
finish,
time
my
they
lord.
will
Let
not-
us finish our
that
argument.
time they will not intervene.
And placing the writ
That time
thereafter
they will not intervene.
on the SSC.
In
Thereafter.
every word they will intervene.
But I
But
was
these types of intervention are not made
My
by
lord, may
them
I-
in other courts. But
My
here
lord,
you
I
are
will-
intervening.
My lord, I am in agreement with my learned senior Mr. Bandyopadhyay, my lord, that I place my case.
But where is the
Our case, my lord, thereafter.
Item 41, there is already an
Yes.
interim order.
There are something which required to be placed, my lord, which I did not place before your lordship. Everybody is saying
For what purpose do you want to place that
what
submission
purpose, my
today?
lord, that is annexed in the writ petition. Two things. Supreme Court has said expressly that expiry of panel is tainted and
not? But this is incorrect.
Illegal.
Illegal.
This is absolutely
Not,
inaccurate and
My lord,
wrong.
it has been said by
It
the
is
Supreme Court.
wrong.
Let me place those two paragraphs only. My lord.
It is wrong. Please read
The
paras
3rd
45,
April's
46,
order
49.
3rd April, sorry.
on paragraph 31.
Paragraph, no, my lord, not
Paragraph 45,
My lord,
46,
if you can fix
49.
that,
my
we don't
lady.
have a case. Tainted and illegal.
May I, my lord?
Yes,
Not
please.
specifically found to be tainted is how the Supreme Court describes them. Paras 45, 46, 49.
My lord, kindly come to page, my lord. I tell your lordship. Paragraph 20.
1 minute prior to you coming to the page, the problem cropped up with item number 7,
Yes, ma'am.
where there is a direction for publication of that panel.
Yes.
I am going to modify that, and I'll mention that the list in similar terms as has been mentioned over here, that they will produce the list over here. Possibly this will be the list
But
because the
deeply
list is
obliged.
already here.
Deeply obliged.
Right? And the matters are
Grateful,
being
very
marked.
grateful,
Let the list
very
be ordered
grateful.
clearly. Otherwise,
Item number 7. My lord, in item number 7, my lord, so far as this list is concerned, it may be produced.
it is
But
here.
what I am praying for publication is list of the candidates who are not specifically found to be tainted other than the 4 categories. That is a way of interim order, my lord, I want to place. That may be published because publication of this list will not prejudice. Later on, your lordship may decide that the So, sir,
I will
kindly.
not hear you.
Sir,
I will not
kindly.
hear you.
Sir, my lord,
Your senior will permit you to speak.
my lord, kindly visualize.
Permission first and then make
Well,
some.
kindly visualize. So far as this list is concerned, that publication of the list of candidates who are not specifically found to be tainted other than those 4 categories. If this list is published, my lord, no one will be prejudiced. Later
No, my
on,
lord,
your
this
lordship may
is
decide that the expiry of panel will be allowed. Expiry of panel may not be allowed. That's all totally different. But my interim order, my lord, to that extent, as of now, a list may be published. So
Tell me, how are you prejudiced if this interim order is not passed in your favor?
my lord, I will be prejudiced because, my lord, there are 2 things. By 31st of December, appointments will be made.
But everything will be subject to the result.
Absolutely, absolutely. At least, my lord, when this list
My
comes out,
lady.
I can be rest
Grateful.
assured that
Safe.
I am not among those candidates.
Then safe.
Yes, I am not among those candidates. I am not among those candidates. Because
Nevertheless, the Supreme Court cancelled all appointments 10 years after the selection process started.
my lord, kindly come to paragraph 42. The reason behind it, the Supreme Court cancelled is that the commission wanted to cover up the entire scenario. Now also, my lord, I specifically allege, I don't know at whose instance the commission is trying to cover up. Your lordship sees paragraph 42. My lord, that is why, my lord, we are the candidates, my lord.
You make submission from behind, then I am not going to hear you. You are not such a junior member that from behind you'll make submission and the court will entertain. Do not do this.
One by one.
It is you who is interrupting.
One by one, my lord. One problem. I want item number 41, learned advocate submission, then another advocate submission, item number 7, my lord. Lordship, I am sorry, my lord, but 41 advocate something, then item number 7 advocate something, my lord. My lordship, kindly, one by one.
My lord, just let me place, my lord, why this list is required. My lord, just kindly, sir, let me complete, sir, thereafter. My lord, kindly come to paragraph 42 of the judgment passed by the Supreme Court, which categorically says that there was a cover-up and dressing up made by the SSCs because of which the entire panel goes. Now, in view of that, my lord, the Supreme Court directs, my lord, in view of that, the Supreme Court directs the High Court must be, my lord, the High Court shall ensure that none of the tainted candidates are slipped through. Now, if the tainted candidates also slip through for this time, my lord, again, my lord, we will be facing difficulty. 2016, 2025.
Court is trying to comply whatever the observation
Yes, my
and the
lord.
direction of the
Yes,
Supreme
yes, my
Court
lord.
is.
Yes, my lord.
Right? Let the list has already been produced.
That is for the expiry, my lord. This list.
I understand the other list is also there. So it can be taken that whoever's name is not there in any of the lists will be not specifically tainted.
My lord, let them publish it. That is the difficulty. My lord, unless it is published, my lord, we will be again.
If out of 10, 6 names are published, it goes on to show that the other 4 are not in the tainted.
My lord, that is that
One way of looking at it.
My lord, but the categorization that who are the candidates.
Involved with the categorization because you want the names of the candidates not tainted, not specifically tainted to come out.
Yes.
Yes.
They do
Not
not fall in
specifically
any of
found
the
to be tainted.
categories.
They do not fall in any of the categories.
They are
Yes.
not categories.
Yes.
So if
Doesn't have
the
stigma.
category list is there, then the other remains.
My lord, other remains, my lord, what? My lord, the commission will not be prejudiced by way of publishing this list.
Also not be prejudiced.
My lord, I will be, because later on again the selection process will be changed. The entire selection process will again already.
You cannot stop somebody from challenging the process.
Of course.
You cannot stop this mess that has happened. You have to try to adjust in this. Right?
My lord, but the difficulty.
Supreme order, my lord, I tell you, Lord.
My lord, may I be permitted to say, my lord, two things? My lord, yes, may I be permitted? My lord, in this case, the petitioner, he is
Which case? Which case?
that item number 7.
7 is over.
No,
I
just
think 7 is over.
Just a minute. He is working. He is untainted.
Let her work, her, him, whoever. There is no particular assertion upon any candidate. What is happening over here is just everybody is making their own submission, and the court has to come
That's
to a
right.
right.
Yes,
So
I
let me understand.
My lord, let them argue. Then at the end, I will argue.
Your lordship kindly comes to page 46 once. I say why I am pressing this, that these expiry list should be published in public domain. Why? I will be placing my first. Kindly come to page 40.
I'll hear you on that. You have made your submission. There are other submissions also. You are for publication, and the
Why
persons
it is
against are also there.
publication?
I will hear.
My lord, for publication, why, my lord? Firstly, in paragraph 20 of the Supreme Court judgment, Supreme Court affirms the 17 illegalities made, which have been stated by the Honorable Division Bench.
Yes.
One of the illegalities is, my lord, that appointments given after expiry of panel. firstly, this has been affirmed by the Supreme Court. Secondly, my lord, and Supreme Court goes on to say that these are illegalities and tainted. And in paragraph 31, subsequently, all these submissions that there was a stay order, it was not that. The first line is the commission tried to justify the extension of panel and it is rejected. And my lord, there is a notification of in the rules, not notification, which specifically says that the validity of the panel is 1 year from the date of its publication, and the rule does not give any power to the commission for its extension.
That has been recorded in the order. I have taken note of that. Yes.
This petitioner, my lord, this petitioner is a pressure candidate. Now, my lord, your lordship know that candidates are being called for interview in respect of particular ratio, based on a particular ratio. My lord, if these candidates are included in what happened in 11-12, my lord, many of these candidates were involved and many of the freshers, because of these candidates, could not come within the zone of consideration. My lord, classes 9-10, verification list is yet to be published. Again, if these candidates are called, many of us, my lord, will not even be called for verification and will lose our chance. For this, my lord,
You will not lose your chance because the writ is kept pending and the court is going.
Again, it will be redone, my lord. Kindly
Again, then it has to be, direction will be passed by the court to redo the whole thing.
We are facing this mental economy every time we do not know what is going to happen. And
can you understand the volume? Is it possible? Now, if the respondents are not heard, if the applicants are not heard,
can be hard,
then
but only point is subject to correction.
Lordship is
only point
hearing,
you
hearing
can see
continuing.
that the hearing is continuing.
Hearing is continuing. You are asking for an interim order before the hearing
Please,
concludes.
please, kindly
The court is hearing.
Yes,
with
hearing is
6, this
continuing.
is a completely different matter. Your lordship, kindly don't fix it with 6.
The issue
This
will
is not.
touch that also. The issue which is
But that's the
involved
root of
here
it, not just
will
root.
touch.
Yes.
Is bound to touch that.
Whole participation will be illegal, all of ours.
Do
in
you
that
follow?
case.
Yes, ma'am. That's true.
You are the fresher candidate and they claim that they are the untainted candidates.
Yes.
Whether both can come in the same group or not, whether it will be a class within a class or not, as was submitted on the very first day. So all these issues will come up.
Let us, deepest of respect, let us presume that your lordship is, in respect of that rule matter, your lordship is with us and your lordship passes an order that this fresher candidate and this tainted candidates, my lord, not tainted, my lord, I stand to be corrected. This 2016 candidates, there will be a separate selection process. Then, my lord, this, even if that be an order, my lord, of your lordship, the order of the division means that these they cannot be published. Stands, my lord, that cannot go away. That even if these
A division bench
Whatever
order has
is
been
there is
modified.
there. The single judge cannot go and modify division bench's order, Supreme Court's order, nothing. Again, you are making submission. You say from here, somebody will say from there. Please don't. The court is trying to accommodate each one. Do not do this.
The lordship,
Right?
the lordship has been hearing in a very patient manner and in an orderly manner.
Yes.
So, if lordship feels
We are
not
grateful
6,
for that
7,
patient
no
hearing.
difficulty.
Item number 7. There will be a change in the recording.
Coordinate bench has already held in this favor, my lord. I just point out your lord. In this
the portion where there is a direction for publication of the list of candidates called for counseling and given appointment after the expiry of the panel, that portion will be deleted.
The lordship may kindly see, my lord, while
Grateful.
Affidavit direction is
there is possibly some observation of your lordships in this order. I just heard that panel expiry. Kindly check that so that doesn't
remains in consonance with
Yeah.
whatever is there.
Deeply obliged. Deeply
Yes.
obliged.
Yes.
Deletion of that
Grateful.
Item number 41, take down an order, please.
So far as the addition of party in 41.
Details of the candidates recommended after the third phase of counseling counseling in connection with first SLST at 9-10 level
and 11-12.
12. 9, 10, 11, and 12.
why the list that has been placed, Commission, is in respect of Bengali grade? Is it Bengali grade is mentioned?
Yes. Bengali, there was stay. That's the reason later on.
This is not great. Probably, I think it's a Bengali graduation. It's a short.
Bengali graduation subject. Bengali subject.
Then each and every subject must be having a different list.
No. Excepting Bengali, there is no other.
Yes, each and every subject is having a different.
Very well. Bengali within bracket grade, GRAD. And the list of candidates recommended after the third phase of counseling in connection with first SLST 11-12 level. Filed in court today, be retained with the records in a sealed envelope. The respondents are directed to file their affidavit in opposition by 23rd of December. Reply, if any, by 6th of January.
Can't be allowed. No?
Release the matter for further consideration on 13th of January.
And my lady, the cans may be allowed in this item 41.
Item number 41, there are 17 can applications.
Yes.
I have the liberty to...
Let copy of the interlocutory applications be served upon the petitioner and the respondents, if not served earlier.
We have also filed one can in this matter, can 6.
That will also appear.
Or certain modification of your lordship.
The application filed by the commission shall also be served upon the
served already.
modification application served.
Can
6 served. দরকার নেই, কেটে দিন লাইনটা। ঠিক আছে?
Can for addition of parties be allowed, my lady? Addition of parties
allowed.
Grateful. I'm so grateful.
The department is directed to make the necessary amendment in the hostile will be open for the added respondents to file their respective pleadings by 23rd. All right. অনিমেষ বাবু, এটাকে একটা খামের ভেতরে ঢোকাবেন বন্ধ করে।
My lady, item 18 is also same issue on panel.
অন্যান্য অ্যাপ্লিকেশন অ্যালাউ হয়েছে, ওখানে একটা রিজন।
Their participation in the interview and
this is to be returned.
Their appointment in second. My lord, their participation in the interview and verification
is subject to the result of the it is mentioned in the order, earlier order.
And the candidate should also be mentioned.
It is already there.
One
And moreover, there is a public disclaimer also. So you are covered by that. All parties are covered.
So far as item 7, my lord, your lordship has modified that expiry portion, but my lord, the public, so far as the publication of the my lord, candidate not specifically found to be tainted, my lord, that portion, my lord, kindly don't modify that portion.
Creating problem. Let us see how it can be resolved.
My lady, item 18
your opposition
also on the same.
You are added. File your opposition and it will be heard.
My lord,
similar issue is being already heard, right?
My lord,
now
my lady, item 18 is on the same issue of out of panel. The issues of 18 and 41 are identical.
Check the writ petition, they are all freshers.
No. Whether the persons who were blessed with the court's order, because act of court prejudice and this was not specific. No objection, he has no objection. Record basic
I am not going to record anything.
My lord,
Item number 8 tha ki holo?
my lord, may I speak for 1 minute?
If he doesn't have objection. Let him be bound. I am not recording any, even if he says I am not hearing. I have learned how to hear selectively. You all taught me.
Presumptuous of me, teaching a judge like your lordship.
Yes, not like I am like y'all.
No,
nothing special.
From by you.
Nothing special.
But still, my lord.
I can sit.
My lord, may I speak for 1 minute, my lord? My lord, may I speak for 1 minute, my lord? 1 minute.
Live stream post होगा live streaming post होगा
Item 9.
Well, item 9, my lord, same, but it is class 11 and 12.
All right.
And my lord, date of publication of the panel, my lord, it is at page 111. It is 27/11/2017.
See, the panel has already been produced in this matter.
No, my lord, not panel. That is the expiry has been produced. Your lordship recorded in the previous order the notification by which the date of publication of the panel. That date in case of 9/10 is different, 11/12 is different. So
Yes.
for 11/12, my lord, I am indicating the
আচ্ছা আসুন তো দেখি 11-12 এ একটা ডেট লিখুন তো
27
ক্লাস 9 লিখে রাখুন এই item number 9 is in respect of classes 11 and 12. Date of publication of panel is
27/11/2017
27/11/2017.
and date of expiry, my lord, 26/11/2018 after 1 year.
well that we are disputing with
ওইটা 7 এর ইনিশিয়াল পোরশনের সাথে ওটাকে অ্যাডজাস্ট করে ঢোকাতে হবে 7 টাইলে আমি 9 টা করে দেব The directions for opposition will remain in 9 also.
But only one thing, those dates regarding what is the date of expiry.
Only 41 and
Kindly, Lordship, ensure that that's a submissions because
Yes, the submission. They are showing records.
Yes,
So
yes.
take your submission.
And my lord, I would be requesting my learned friends on this point. There may be several matters, so that my lord all go in the same boat and Lordship decides finally.
Yes, 10.
10, my lord, I am for the petition.
এটা কোনটা?
My lord,
What is the issue over here?
here, my lord, untainted teachers have come before your lordship last occasion. My lord, your lordship, that they challenged the 2025 rules. 2025 rules was challenged by the teachers, though are still now permitted to continue their service till 31st December 2025. And one of the petitioner earlier, that point was raised by my learned friend, page 71. Just I recapitulate your
What is the
lordship.
ground of challenge?
Challenge that, my lord, according to Honorable Supreme Court, 3rd April 2025, 17th April 2025, nowhere it is stated that the new rule will be framed. Only stated that advertisement will be published, my lord. Not only that, my lord, we are affected. Two unequal group, two unequal class, my lord, are compelled to
Will the petitioner number 1 carry the writ petition, or will it be carried only by the petitioner number 2?
Before your lordship, regarding order 2, rule 2, I am relying upon 2 or 3 judgment of the Honorable Supreme Court.
The position of law first and then the judgment.
The position of law, my lord, here in the instant case, page 71, the petitioner number 1, my lord, made a prayer before this honorable court in the first writ petition to my lord, to create a new vacancy in respect of Persian general. But that prayer was rejected by your lordship. Only simple prayer and along with a, my lord, representation. My lord, during the course of hearing, the petitioner number 1 came to learn, my lord, due to the 100% roster, my lord, that post, my lord, transferred into Persian general to Persian SC, scheduled caste. And thereafter, my lord, the petitioner number 1, my lord, challenging the entire rule along with 100% roster in view of the fact this is the ongoing process pursuant to the order, my lord, this is the exceptional recruitment process, my lord, pursuant to the order of the Honorable Supreme Court. Nowhere it is stated that the rule will be framed and thereafter advertisement. Only say advertisement and say post, above post, 17/4/2025. I am not, my lord, traveling your lordship. So, my lord, 17/4/2025 it is stated. Advertisement published in respect of said post. My lord, with due respect, I am submitting before your lordship, the cause of action are totally different. Fundamental rights of the petitioner number 1 has been infringed. My lord, not only that, with due respect, I am submitting before your lordship, the petitioner number 1, my lord, was permitted by the Honorable Supreme Court, batch of the matter, to permit to set in the written examination 2025. So, my lord, the cause of action, or this is not a case like orders to rule 2 that one relief, my lord, I have not placed. Subsequently, that relief I have placed. That is not a case, my lord. I am relying upon 2 or 3 judgment, my lord, regarding that portion, my lord, orders to rule 2.
3 judgments.
Get office copy. AIR 2021 Supreme Court Supplementary 382. My lord, paragraph 568. AIR 2021 Supreme Court Supplementary 382. Earlier, the petitioners that approached this court by filing paragraph 5, whereby they had claimed that they were entitled to pay an allowances and other benefits under Rule 6 quoted herein above. Their petition was allowed and respondents were directed to give full benefit of Rule 6 of the Supreme Court Legal Service Committee rules by fixing the pay and allowances of the petitioners and other similarly situated employees in the pay scale specified in the schedule appended to the rules or at par with the central government employees holding equivalent posts, such and such. The Union of India has raised a twofold submission. It is first submitted that the service of the petitioner rendered prior to I am not on that. It is secondly contended that this plea could have been taken in the earlier petition. And in fact, such a plea was raised, but finally the court did not grant this relief, and therefore they cannot file the second petition. Thereafter, kindly come to my lord. I am paragraph 8. I am not consuming your judicial time, my lord. As far as the second submission made on behalf of the Union of India is concerned, we have carefully gone through the earlier order and the writ petition. Though it is correct that in the writ petition there was a general claim to grant all benefit under Rule 6, which would include retail benefit, but it appears the court did not go into the same. There is no rejection of the plea, and as such we are of the considered view that the petition is maintainable, cannot be rejected on this hyper-technical ground. In relation to applicability of Order 2 Rule 2 of CPC, this court has held that Devendra Pratap Narayan Rai Sharma, State of Uttar Pradesh and others are as follows. Paragraph 12 quoted, the bar of Order 2 Rule 2 of Civil Procedure Code, on which the High Court apparently relied, may not apply to a petition for a high prerogative writ under Article 226 of the Constitution. But the High Court having disallowed the claim of the appellant, such and such, my lord. And that judgment, my lord, Devendra Pratap Narayan Rai, That is, my lord, paragraph 12, Devendra Pratap, that is AIR 1962, Supreme Court 1334.
Three judges, 4 judges, five judges.
55. And my lord, 5 judgment, another judgment, my lord, paragraph 26. AIR 1965, Supreme Court 1153. Paragraph 26. Before we deal with the question, we may dispose of the short points urged for the appellant. It is urged that if a decision in a writ application on merits be held to operate as res judicata in a regular suit, the provision of Order 2 Rule 2 CPC would also be applicable to the institution of the subsequent suit with respect to such part of the cause of action for which no relief was sought in the writ petition. The contention is not sound as the provision of Order 2 Rule 2 only apply to suits. Sub-rule 1 requires that every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action. But the plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. Sub-rule 2 then provides that where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. By its very language, these provisions do not apply to the contents of a writ petition and consequently do not apply to the contents of subsequent suit. Such view was indicated by this court in such and such.
All right. And what is the case on merits?
My lord, I have categorically stated in paragraph 12 onward. That the Malad 3rd April at 3rd April, paragraph 49, Honorable Supreme Court, my lord, held that similarly other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Paragraph 49. In our opinion, such a direction would be fair and just as it would allow these candidates to take part in the fresh selection process, which should now be initiated to fill the vacancies. Here in the instant case, in many other subjects, petitioner number 2 is the physical science 910, 312, my lord, seat decrease. My lordship, well aware. Page paragraph 49, vacancies. Thereafter, if your lordship kindly come to 17th April order. 17th April order today. My lord.
Do you have any reason as to why the commission could have decreased these seats?
That is according to the commission, West Bengal Board of Secondary Education, that 100%, change according to 100% roster.
No, that is different.
Different. Decrease.
Decrease in seats.
We are surprised. This is after 9 years decrease. Yes, after 9 years decrease.
No, in between there was no selection process.
No selection process, but,
Right.
but some person retired, some person died.
So what? The candidate should be there.
Candidate, post should be there. The post should be there. So no.
Without the candidates, the post will be there. Where are the students?
My lord, it is very surprising how after 9 years, my lord, vacancy decrease, my lord.
Why? What is the surprise over here?
My lord,
How many students go to these government schools?
my lord, that is, my lord, if your lordship.
All right, let the commission say as to
Not
what
only
is
that,
the
not only that
requirement.
point, my lord. Second point, my lord, academic.
Academic.
Academic, according to 2016 rule, Madhyamik, Uচ্চ 10 plus 2, graduation, post-graduation, BA. Every mark, my lord, added, my lord, percentile wise. But now, only graduate, post-graduate. If a person, my lord, in the graduation level, somehow happened in the family, did not get more marks, then, my lord, he will be out. Not only that, my lord, fresher candidate raised a question 10 experience. With due respect, I am submitting on instruction. After adding 10 numbers or 6 or 7 numbers, at least 500 candidates already, my lord, left out from the battle, my lord, from the recruitment process already, my lord.
No, I did not follow this.
My lord, the fresher candidate, they said that 10 marks in experience category for experience, my lord.
Before, because of given this prior experience, the freshers are being prejudiced. This is your case.
My lord, but we also prejudice because of the fact it is not for only 2016 candidate, contractual, part-time, aided, sponsored, government. There are so many matters pending before your lordship. Another ambiguity. Voluntary teacher also filed petition before your lordship. So, my lord, and for that reason, my lord, my instruction, at least 500 teachers, untainted teachers, already left out after the written examination. Because of the fact.
Because they could not compete with the others.
Yes, why? I am asking a question. Why?
You do not have the merit.
No. Because of the fact, your lordship know better than me. My candidate passed in 2007, 2008. That time, the pattern of question, and now the pattern of question MCQ, and that time pattern of question 12 or 9 or 6, and awarding of marks, and that time 2007, most of the candidate, my lord.
What is to be done? If you do not compete,
in the academic, we do not get the marks.
If you do not
along
compete,
with the new candidate.
I got it.
Not only that, my lord, another point, my lord. My lord, in the academic, my lord, it is not possible for a candidate whose age is 45 years, 46 years, to compete with a 23 years old boy or girl. Now the greatest, my lord, marking system, MCQ has come. Not only that, my lord.
How will you teach students if you do not know? You want to be recruited as teacher, right? How will you teach the students if you do not know?
My lord, in written examination, we got out of 60, 56, 58, 54.
Then it's all
right. My lord, because but most of the teachers who passed in the year 2006 or 2007, they are not benefited in academics, my lord. In
this
academics,
is
they are not
exactly the
benefited.
case of
And
the.
not only that, two equal groups, my lord, and this is the contention of the Honorable Supreme Court, that my lordship kindly have a look into my prayer only. 1 second. Read in the nature of mandamus to conduct de novo examination strictly on the basis of the West Bengal School Service Commission 2016 rules. But with due respect, I am submitting one thing. non-challenge to 2016 rule in earlier proceeding. Earlier proceeding was, my lord, cancelled for, my lord, corruption. Never they challenged. But in case, with due respect and submitting with judgment, in case of Tripura, your lordship well aware of the facts. In case of Tripura, they challenged the recruitment policy. For that reason, Supreme Court said, you introduce recruitment policy and thereafter advertisement and thereafter proceed the case. Here, the contention of the Honorable Supreme Court, advertisement, not introduce new rule. And another thing, my lord, the rule was framed section 17, 17B. Lord, if your lordship kind of a look into the 17B, nowhere it is stated every year when you proceed for new recruitment process, you have to frame a rule.
Okay, are you paying for an interim or?
Where is the bar?
No bar, but we are, but it is a continuation. It is a continuation of 2016 proceeding, my lord. And another thing, my lord, I am not disturbing the recruitment process. We are not, because of the fact my alternative prayer is there, my lord. Prayer D.
Yes.
Alternatively, is to read in the nature of mandamus, commanding the respondent to segregate the marks of written examination held on September 7, 2025 or 9 of all candidates who earlier also appeared in 2016, and then to take steps enumerated in Rule 12(6) of the 2016 rule strictly. Thereafter, and time is very limited, my lord, short, within 31st December. And our post has already been, my lord, 100-point roster on the guise of the 100-point roster, and some vacancy. Well, the vacancy has already been decreased, my lord. And
The vacancy status was published at the time of advertisement.
No, thereafter. Indicative vacancy thereafter.
Indicative vacancies was there.
Thereafter, no, it was not 29, 30th May.
When was it published?
13th June indicative vacancy report.
13th June indicative vacancy report.
Right? You have participated.
My lord.
Relying on that.
My lord.
You knew that in Persian and in physical education or whatever, there were no
They
posts.
permitted us to, my lord, to sat in the written examination.
Yes. So you have sat.
But now
there is nothing.
But
you could have come at that point of time.
That point of some candidates on teachers have come, and that matter, the opposition reply. That matter is
Then
pending.
it will be decided. Then what is to be decided afresh over here? You have filed this only on 5th of December, when the list also have been published.
The final vacancy declared.
Final vacancies later on. In the tentative vacancy also, you didn't have a chance. In the tentative list also, you didn't have a chance.
If your lordship kind of chance a tentative vacancy, in tentative vacancy that
it is better let them file their opposition and we'll see what is to be done.
Yes. Regarding
31st. Their 31st December is the last
is a deadline. Supreme Court has fixed it. So this court cannot alter.
My lord.
Then whatever will happen will happen.
Your lordship wants us to make submissions.
Make submission on the next day. If there is no interim order at this stage, then
Well,
nothing doing.
no, the regarding maintainability of the
Assuming
petition.
it is not maintainable at the instance of the petition number 1.
At the instance of the petitioner number 2.
It will continue. Then why go into all this?
Kindly decide the first point. He has relied on judgments of 1960s which say may not apply.
You
also.
Will it be right if I go on deciding this without going into the other matters? It won't be right. Please come.
Kindly keep the question of maintainability at the instance of.
I'll keep it open. The petitioner has participated in the recruitment process for appointment of assistant teachers within 2025 recruitment process of year 2025 for recruitment of assistant teachers conducted by the commission. Stop. They are the candidates who lost their job in view of the order passed by the Honorable Supreme Court in Civil Appeal number 4800 of 2024 in the matter of Theatre West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. That's it. They allege that the fresh selection process ought to have been conducted in terms of the direction passed by the Supreme Court in accordance with the 2016 recruitment rules and not the 2025 recruitment rules. Stop. The Supreme Court never directed the Commission to conduct selection process by introducing fresh rule. Stop. In the fresh rule, the mode of assessment of the educational qualification of the candidates have been changed from the one that was prevailing in the year 2016. The number of vacancies in respect of the post in which the petitioners were earlier serving has either been reserved for the reserved category candidates or the strength of such posts has been decreased substantially. The same is adversely affecting the right of the petitioners in participating in the recruitment process. Stop. The respondents oppose the submission made on behalf of the petitioners. Stop. It has been submitted that the writ petition at the instance of the petitioner number 1 will not be maintainable, as the same will be hit by the provisions of Order 222 CPC. So, paragraph. The matter is required to be heard. Stop. Let affidavit in opposition be filed by the respondents within 23rd December. Reply, if any, by 6th. Released on 14th of January.
Gate could you lose? Judgment kept in the record, man.
Want to take it back? You can take it back. Because I have not recorded anything. Next time it is if it is required, you can have this.
Yeah. Gate could you
due to wrong fixation of pay scale, after refund, initially the CTF to GTF, he deposited the amount. Now after processing pension paper, objection was raised due to wrong fixation. After depositing the amount of 1,17,000, the PPO has been issued.
What do you want? Refund?
Yeah, only refund, my lord. Duto video দিয়ে দাও 7,54,000 was deposited for government share amount. Thereafter, my lord, the DI has raised objection that he was drawn excess amount due to.
The PPO was issued in 2015.
2015.
Yes, you are filing the writ petition after 10 years. And you want relief? Why will it be entertained?
24 melody I have filed.
Yes. What is your submission?
Lordship, in this matter, Mr. Biani is appearing for state. Lordship, we received instruction, but this is not sufficient, Lordship. This is not sufficient, Lordship. Kindly, Lordship, give me 1 week so that I get proper instruction, Lordship.
I am not disputing that regarding wrong fixation.
For more than 1 year, the writ petition is pending. You couldn't obtain instruction.
Lordship, I get instruction, but this is not sufficient, Lordship.
That came to your mind when the matter is being heard by the court. Then?
Obviously not, Lordship.
What is the insufficiency? Let me see your written instruction. What is the insufficiency? What more details do you want?
Lordship, at last para, they said that they requested to review the pay fixation and refund the overdrawn salary. They requested to school, Lordship, for reviewing the matter, Lordship.
Yes.
DI requested to school, but
When?
after that,
When?
Lordship,
When was this request made?
Lordship, on 2013, Lordship.
The PPO was issued in 2015 and the request for review was in 2013.
No, Lordship, on 2024. 2024, as I received their instruction. In 2024, Lordship.
Request for review was made in 2024.
Lordship, kindly give me, Lordship, at least 1 week, Lordship, because I am not in the matter, Lordship. Mr. Biani and another junior is appearing in this matter, Lordship. Kindly give me, Lordship, at least 1 week, Lordship.
Please come. Affidavit of service filed in court is taken on record. Stop. The petitioner retired from service on 27th September 2014 and pension payment order.
April 2013.
Acha, 30th April 2013. And pension was paid to him with effect from 27th September 2014. Stop. The PPO was issued in his favor on 16th June 2015. Prior thereto, the petitioner was directed to refund a sum of rupees 1,17.
That was wrongly melody I have given, sorry. 2,25,453.
Achha, 2,25,453. Which the petitioner did by way of treasury challans. In January 2015 and February 2015. Stuff. The instant writ petition has been filed on 15th of May 2024, seeking a refund of the amount that was directed to be paid immediately prior to retirement. Stuff. Reliance has been placed on the judgment passed by the Honorable Supreme Court in the matter of State of Punjab and others versus Rafiq Masi, within bracket Whitewasher and others. Reported in 2015, 4 SCC 334. Stop. Next. Learned advocate representing the state seeks time to take instruction in the matter. Stop. On such prayer, release the matter for further consideration on 5th January 2026. Written instruction from the concerned District Inspector of Schools shall be placed before the court on the adjourned date.
Right.
What is your name?
Shomojit Ghosh. I already given.
Your name has been given. ওনার নামটাই দেবেন শুধু। আর যে নেই তাদের নাম দেবেন না appearance। না দুজনের নাম হবে না, একজনের নামই হবে। উনি যাই দিন একটাই নাম দেবেন।
ওই অর্ডারটা দিয়ে
12 mile. A lady say beg to appear for the statement.
I'm for the petition. আরেকটা একটা অর্ডার আছে দরকার নিচে
স্কুল লাগে হবে না নাকি সলিউশন
In the second round of litigation, my lord, the petitioner was appointed as a headmaster of
last meeting
headmaster, my lord, of Govind Prasad High School, my lord, in the year 2000.
মিটিং এর কথাটা এতে বলেছে
From 2005, my lord, the petitioner has been restrained by the meeting committee and the members of the said school to enter the school premises.
লাস্ট হচ্ছে যে
To enter the school premises from 2005. 2005, my lord, the petitioner has been restrained from entering the school. The petitioner made several complaints.
দেখা গেল যে
Petitioner filed a writ petition in the year 2020. Coordinate bench directed the petitioner to
August
join.
24 এর
Petitioner with the help of the DI tried to join the school, but he was not allowed to join. The DI was the matter traveled to contempt, my lord. In contempt, the DI filed a compliance report stating that the school authorities, the DI personally visited the school, but the school authorities did not allow the petitioner to join. My lord, the coordinate bench subsequently, my lord, in the contempt, my lord, directed for a recent hearing by the president of the board, my lord. The president did a hearing, and my lord, the hearing is at page 84. The resolution of the hearing is at page 84.
Yes.
Wherein, my lord, the petitioner was directed to sit with the school authorities and, my lord, amicably settle the dates of absence. Lord, the meeting was, another meeting was held, but there has been no resolution regarding the same, my lord. The school authorities are not willing to, my lord, amicably resolve.
What is your age now?
I am 70 plus now, my lord. My salary stopped since 2005. My
When
lord.
did you retire?
I retired in 2015.
So from 5 to 15, 10 years.
No salary, my lord. I have
No salary also.
salary. I am not getting pensionary benefits, my lord, as my date these dates have not been resolved by the managing committee of the school, neither the, my lord, DI.
Where is the board?
board I do not know Board, but we I do have not from know, the headmaster. Yes, I'm application Miss Bhattacharya appears that
My lord, this is the decision, my lord, which we have taken, my lord, on 27 July 2024, where the, my lord, the amicable settlement of the dates, my lord, came into the, my lord, for a decision.
unauthorized absence. The issue is
Unauthorized absence. Now, my lord, we could not get any papers regarding which, my lord, he can substantiate that on a cogent reason he was absent from the school. So, my lord, that
What is your stand as to why he was absent? Deliberately?
Yes.
Unauthorized?
My lord, no disciplinary proceeding till date, my lord.
What
I have
steps
said
did
till
the
the time I
school take
superannuated.
against him
My
for
lord, since
remaining absent?
2024, my lord, on 27, can you see the, my lord, resolution which was taken?
There's been no disciplinary proceeding till the time I superannuated, my lord.
Please read out
My lord.
and give a copy to him also so that he gets to know what is there.
27/7/2024 তারিখে বেলা 2:30 সময় বিদ্যালয়ের অফিসে টাইম রিডিং ফ্রম দফায় দফায় বিদ্যালয়ের অনুপস্থিত সময়কাল হলো 1/7/2005 থেকে 20/8/2007, 9/10/2007 থেকে 29/9/2008 এবং 1/4/2009 থেকে 30/9/2015 পর্যন্ত, অর্থাৎ সর্বমোট প্রায় 10 বছর। অদ্য এত তারিখে বেলা এতটা বিদ্যালয় অফিসে উক্ত আবেদনপত্রের বিষয়ে বিস্তারিত আলোচনা করা হলো। এত দীর্ঘ সময়কাল অনুপস্থিতির জন্য সবেতন ছুটি মঞ্জুরের কোনো গভর্নমেন্ট অর্ডার বা নির্দেশিকা বর্তমানে পরিচালনা সমিতির কাছে না থাকার কারণে সর্বজ্ঞ ছুটি কোনোভাবে মঞ্জুর করা গেল না। So, my lord, my lord, I have forwarded this decision to the board. If the board says yes, you, my lord, board grants the permission.
That I followed.
Then,
But then, is there anything on record to suggest as to why the petitioner could not join the school?
My lord, he can explain that, my lord.
Lord, I went to join the school several times.
Show me. Why? When did you get the job?
I joined in 2000, in the year 2000.
And on 2000, from 2005, what happened that you were prevented from entering the school?
My lord, the very first incident happened in school when I was confined in a schoolroom and the local police authorities had to come and unlock and bring me out of the school.
All
This
right.
was the very first incident. After that, my
In
lord,
2005.
in 2005, my lord.
Right.
After that, I have been trying to join the school, my lord. I have made
Why? For what good reason will a teacher be held inside the school under headmaster of the
I
school?
protested for the issue with midday meal in the
Alright.
in the school, my lord. I
Alright.
myself protested for that, and because of this that reason, my lord, I have been, my lord, in this situation since then.
Where are the communications complaints lodged before either the police or the DI or the board? Anywhere, do you have any document to show that you protested?
My lord, kindly comes to, my lord, page 47.
Yes.
Page 47 is the report of the DI, compliance report of the DI filed in the contempt proceeding, my lord. Starts from, my lord, page 43. The relevant page, my lord, is page 46, my lord.
Yes.
Page 46, my lord, paragraph F.
Yes.
My lord, may I place, my lord? That on 14/9/2013 by memo dated such and such.
Is the date 13? I can see 201.
2011, my lord.
2011.
Apologize, my
It
lord.
will be 11? All right.
The DI of the school, DI Bakura, requested the managing committee to allow the petitioner to resume his duty. On reply, the managing committee informed that they have no knowledge about the allegations made by the petitioner. Lord, the next page, my lord, paragraph H. The memo dated such and such. I direct the secretary of the managing committee to allow the petitioner to resume his duties as headmaster. Otherwise, no grant in aid will be extended in favor of the said school. Similar paragraph I, that on 1/4/2015, I, along with two assistant inspector of schools, Bakoda, went to the said school for smooth running of the teacher, and discussed with the managing committee, but they raised their voices by several allegations in respect of the petitioner and did not allow the petitioner to resume his duty. I requested the officer in charge of Gongajal Ghati police station to take necessary steps so that petitioner can resume duty. Thereafter, my lord, I retired in 30th September 2015, my lord.
These are all in 2011, my lord. He was absent from 2005.
This covers, my lord, the matter started in, I filed my writ petition in 2013, my lord. So from 2013, my lord, 2015, the contempt proceeding, and this is the report filed by the DI in the contempt proceeding. This is the compliance report of the DI.
The first lap, he was.
Is the board a party over here?
Yes,
Board is a party.
First,
Is the board not represented?
Yes, Your Lordship. She is at court number 11. I am asking her to come.
Where is the board a party?
yes, yes. Party children? Party.
Yes,
No,
sorry.
Ja.
Vital.
What? Yes, I'm looking at the cost title. I don't
we have,
see any
we have also
document.
seen
Yes.
board has intervened in as per our report. Oh, we were of the method. That usually it's ought to have been.
Was any direction passed to add the board as a party?
No.
No direction was
Then,
my lord,
because the presence of the board is required.
due to inadvertence.
The
I missed the to add board
Right.
as a party, my lord. I grant
Mm,
liberty to add board as a party, my lord.
see, what the court can do is already there is a resolution. The court can forward it to the board for hearing all the parties and for taking a decision. That
The
is
board has already taken a
one
decision,
way of that was
No,
earlier,
earlier, my
not after the resolution of the school.
my lord.
That is one way of looking at it. Or otherwise, you have to implead the board. The board will come and make submission, and thereafter, I do not know what's going to happen.
My lord, better, my lord.
Better, my lord. I grant, my lord grants me liberty. I'll add board as a party, and otherwise again the
My lord,
same thing will happen, my lord.
after,
Again I have
my lord,
to come
may I
with
submit, my
another
lord?
writ petition before
After the, my lord, decision of the managing committee, my lord, we have, my lord, forwarded it to the board. Now, my lord, the issue, my lord, has to be resolved by the board, my lord. regarding the unauthorized absence.
No, this one order.
2011, prior to that, from 2005 to 2007, first leg, my lord. Then, my lord, 2007 to 2008.
You
Thereafter,
are the school.
yes,
A teacher is not coming, not teacher, a headmaster of the school is not coming from 2005.
there were some allegations, my lord, against him.
Right. What steps did the school take?
That,
Nothing.
No suspension and no disciplinary procedure.
Even after the court passes order, you do not allow the petitioner to join. The DI goes, you do not allow the petitioner to join. You permit the teacher to retire from service. In the year 2015, the person is aged 73 years now, without any income, without any pension, without any retirement dues. How will this person survive, will you say?
That's
Then,
so, my lord.
please come. The petitioner is a 73-year-old retired headmaster of a school.
70.
70 years. Stop. He has not been paid his terminal benefits because his leave has not been regularized. Stop. On a perusal of the writ petition, it appears that the West Bengal Board of Secondary Education has not been implemented as party respondent in the instant writ petition. Stop. The presence of the board will be required for effective adjudication of the instant lists. Yeah. In view of the above, leave is granted to the advocate on record of the petitioner to implead the West Bengal Board of Secondary Education as party respondent in the instant writ petition and serve a copy of the writ petition upon Miss Koili Bhattacharya, learned advocate, who usually represents the board before the court. Step. The board it appears that the school has taken a resolution in compliance of the direction passed by the court with regard to the leave of the petitioner.
Page 84 is also there by board's reason also.
Stop. Let a copy of the resolution be handed over by the learned advocate representing the school authority to the learned advocate for the petitioner for onward transmission to Miss Bhattacharya. Stop. The board shall forward necessary instruction on perusal of the resolution of the school and the documents annexed to the writ petition, particularly the affidavit by the District Inspector of Schools affirmed. Where is the affidavit?
Page 49. Page 49.
Affirmed
20th April 2015.
On 20th April 2015. Annexed at pages
43 to 49.
43 to 49. And more specifically, paragraphs F and F, H and I of the same. Stop. Release the matter for further consideration on 5th January 2026.
Under the same heading, my lord, urgent motion.
Urgent motion.
For item number 13 is
This
being
matter, there is a direction for service of a copy of the writ petition upon you along with a resolution of the school It relates to regularization of leave of a teacher. Come up with your instruction.
My lord, before your lordship takes up item number 13, my lord, I'm only one mistake, my lord. Item 41, my lord, when the commission will come, my lord, two things. There were two directions. The list was produced before your lordship, and there was another specific direction to publish the OMR sheets of all the candidates, my lord, who participated in second SLST for transparency, my lord. That has till date not been published.
That order remains. Whatever is required to be done, please do. Yes, 13.
13, I am for the petition.
Yes.
This is my lord, the petitioner husband, my lord, was an assistant teacher. The retired in 2004. He was under CPA. That is why, my lord, his pension papers ultimately husband died 14th March 2022.
Who died? Husband.
Husband died.
Ah.
My widow has come, my lord, for grant of family pension, subject to refund of the government share with interest. My lord,
the teacher came to court earlier.
No.
Teacher never came to court.
The pension papers, page 23, she applied after the death of her husband. My lord,
23.
না এটা তো করেছে তারপর আর করেনি তো my lord, the identical order, but in that case, my lord, the teacher concerned, my lord, the died or retired prior to the notification.
Here the teacher did not do this. Not only that,
but it has been covered by the Muktimoi Pal. My lord, the Muktimoi Pal herself is a teacher. My lord, although he exercised option under UPA 90.
No, did the teacher, that means the husband of the petitioner, exercise the
90? Yes,
UPA 90
that
benefit was.
Yes, that 90. UPA 90. That is not the disputed. Only your lordships. After the notifications, well, prior to the notifications, well, the concerned teacher did not.
But then 2004 retired. The notification came in 2014.
2014.
And the person expired in
2022.
Then it means that he never wanted. Now the wife cannot come and say that I want it.
Well, wife, well, we required to refund the government share with interest. Well,
that is different.
How long?
That
how
is
you will avail, well, the family pension, I don't know, but the maximum 10 lakhs, 15, 20, 12 lakhs has to be refunded with 12% interest.
But then whether this can be done at such a late point of time, this you have to think.
But
see the timeline. 2004.
Pension, poor,
let the lady enjoy the 10 lakh and 12 lakh which she is required to refund. What is the use?
But no pension, nothing has been released in favor of the teacher also. Nothing after retirement, after death.
Obviously, because he did not opt for it.
But
and it was
the gratuity minimum, he is entitled, the gratuity
he did not
also.
come forward. From 14 to 22, he was alive. He did not come forward.
22, yes.
Isn't it? How can this be allowed?
No,
this will be an absolute stale claim.
Widow has come, there is a
widow has what point of time?
No,
widow has come, I understand, but the time.
That's true. The widow has come, the 22 retired, the widow has come. She did know after the death of her husband, the widow is suffering from very financial crisis. She wants to refund the amount. Your lordship, this. Yes, these my lords also. This is the teacher concern expired in 2012.
And the lady is 44 years only. Huh?
44 years.
That is what you have written in your affidavit. Let her go and find a job for herself instead of looking for pension from her deceased husband.
Yeah. 81. Yes, 44, rightly.
Ah,
44.
let her go and look for a job.
My lord, the,
No, nothing.
pensionary
Please come.
benefit. Your lordship, kindly see, my lord,
The petitioner
there is a judgment, my lord,
claims to be the widow
your lordship,
of
kindly, my lord, order.
of a secondary teacher who retired from service in the year service on 31st January 2004. Stop. The husband of the petitioner did not exercise option to come under the GPF scheme. Stop. The husband of the petitioner expired on 14th March 2022. Stop. The instant writ petition has been filed by the widow on 5th July 2025, seeking direction upon the authority to permit her to refund the share of contributory provident fund along with interest and additional interest, so that she may avail the benefit of the GPF scheme. Stop. Next. None appears on behalf of the respondents. Stop. On a perusal of the dates mentioned herein above, it appears that the teacher himself survived for quite some time after his superannuation on 31st January 2004. He expired on 14th March 2022. For the 18 years that the employee remained alive, he never thought of switching from the CPF to the GPF scheme. Stop. He never raised any issue before any forum highlighting any grievance.
Firstly, your lordship wants to see the representation, my lord, page 23. He want what
The same implies that the employee never had any objection to continue with the CPF scheme. Stop. After the death of the employee on 14th March 2022, the instant writ petition has been filed by the widow on 5th July 2025, seeking change of option. The court is not inclined to accept such prayer of the widow in the facts and circumstances mentioned herein above. Stop. If the employee did not seek for the benefit, the widow cannot agitate such grievance before the court. Stop. Next. In view of the above, the writ petition fails and is hereby dismissed.
23, teacher in charge, actually, teacher in charge forwarded the pension papers to the DI.
All right. No option forwarded the
apart from
pension
the
paper.
GPF, my lord, the other benefits should be released. Whatever the dues your associate direct that. I am not paying, my lord, to convert CPF to GPF. My lord, the other dues.
Other dues, the employee also never came.
But that benefit
And
cannot be.
he ought to have come within 3 years or something. He enjoyed. He was happy with what he got.
Other benefits.
No, nothing, sir.
What is the entitlement, my lord, that
Nothing.
she is well entitled.
Next. 14.
I'm for the state of the rights.
Yes.
14. My lord, the 14. My lord, the Krishna retired from service. Retired from service. October 2024. My lord, pension paper was processed back to that because of the criminal case pending. Well, outside the criminal case pending, no relation regarding my lord the
service.
Because of the incident happened, although during my lord the within the school premises, but the criminal case now.
When did the criminal case start? 22. November 2022. 354.
2022.
My lord, kindly.
He retired. I tell you, he retired on 2024. 20 prior to 18 months, my lord, the pension papers were submitted. That has been submitted on 31st January 2022. Page 30. Now the objection raised, my lord, because of the criminal case pending, the his pension papers have not been processed.
Yes.
Relying their judgment of your lordships.
Yes, please give.
Lordships,
Okay. My lord, as per DCRB 16 sub-rule 5, there is no distinction between personal case, this case in the school premises. It clearly reads, may I place before your lordship, DCRB 5. May I read it for your lordship? Final pension, gratuity, etc. shall not be sanctioned to an employee. Final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental judicial proceedings have been instituted continued. So, my lord, there is no distinction in DCRB sub-rule 15 of 19 that whether it is related to service or not related to service. So, in terms of the DCRB scheme, he is not entitled since any judicial proceeding is pending. One. Second, my lord, kindly come to page 41 as my kindly come to page 37 for once. 37, his application. At the bottom, he says whether any court case regarding pay and service pending disposed of. He says yes. Lordship has found
37.
Page 37, bottom, last line. Now, my lord, kindly take the next page. The details of the case is given, page 38, in the relation to personal matter. Right, my lord, kindly come to page 41 now. That my learned friend is submitting. It is not related to his service. My lord, I am not willing to read the complaint. Kindly see, it is because of outraging the modesty of two women staff in the school premises itself.
In the school.
Yes, kindly read the complaint. I wish
54.
page 41. 41. Kindly allow me to make myself. My lord, I wish not to read it loud. Consider yes, that will be decided in the criminal trial.
Yes.
My lord, kindly see. I am not willing to read out. Kindly see, my lord. Since modesty of women are concerned, yes, that would be decided in the criminal trial, not here.
2020.
Kindly see.
Happened on 16 March.
Maybe that would be kindly see.
After 6 months.
Let me place my case.
And two complaints at the same day.
That is subject matter of trial, not here. Based on which FIR has been lodged. You have not challenged the FIR. Quashing of FIR has not been made. Two lady staffs, not one. And he being the headmaster of the school, taking advantage of his position, this has happened. And
the complaint is not very palatable.
And
inside the premises.
kindly see the FIR copy at page 40.
12 November 2022 complaint was made. Happened on 16 March after
That is the merit of the complaint. Merit of the complaint.
That is the merit of the complaint, investigation, trial. Then, but because of the criminal case,
Yes, DCRB 16(5). DCRB scheme says so.
That has been
any pending judicial proceeding.
That has been decision of this honorable court. Yes, my lords also, my lord, the relying that, my lord, sir.
No, but then in this matter, judgments that you are relying, the criminal offense was nowhere related to
yes, absolutely.
This was not related to, my lord, the defalcation or misapplication.
No,
it's not a matter of defalcation. 354 is something else.
Yes.
Please come.
And my lord, he has given false statement that personal issue, not a personal issue.
The petitioner is a retired headmaster of a school. Stop. He has not been paid his terminal dues because of pendency of a criminal case against him. Stop. The learned advocate for the petitioner submits that the case is the criminal case is in no way related to the service of the petitioner and accordingly, the terminal benefits ought to be released in his favor. Stop. In support of such submission, reliance has been placed on the order passed by the court on 14th November 2025 in WPA 2959 of 2024.
The reported judgment also.
In
That is
this
paragraph 3.
in Manik Chandra Sarkar versus State of West Bengal and others. Reliance has also been placed on the judgment delivered by the court in the matter of Gunamoy Mahato versus the State of West Bengal and others, reported in 2022 4 CHN 381.
What is it?
Stop. Prayer has been made to direct the authority to release his terminal dues. Paragraph: learned advocate representing the state respondents opposes the submission of the petitioner. Stop. Learned advocate appearing for the state respondents on instructions opposes the prayer of the petitioner. Stop. It has been the complaint relying on which the criminal proceeding was initiated is annexed to the writ petition. Stop. The FIR dated 12th November 2022, when the petitioner was in service, is also annexed. Stop. Charges have been framed under sections 354/506 IPC. Stop. The complainants are there are two complainants. Stop. The complainants are the employees of the school where the petitioner was serving as the headmaster. Stop. Next. On a perusal of the written complaint, the court is of the prima facie opinion that the offense in question appears to have been committed within these school premises, and it cannot be said, at this stage, that the said criminal proceeding does not have any nexus with the service of the employee. Stop. Next. There may not have been any pecuniary loss to the institution, but the allegations leveled against the petitioner are such that the court is not inclined to interfere in the instant writ petition for providing any relief to the petitioner. Stop. Next. The writ petition accordingly fails and is hereby dismissed. No, nothing. Instruction forwarded to the state respondents also rely on the DCRB scheme, 1981, and submits that as per the scheme, the terminal/pension cannot be granted in favor of an employee where a criminal proceeding is pending. Next. Dismissed.
Petitioner's father died on 12 January 2004. She was under CPA. Only the claim for the death gratuity. Although the repetitions the now
2004 and you are coming in 25.
Your Lordship can see that the process pension papers were processed. Your Lordship, I have 70 and petitioners was the nominee of the EC teacher. Their petitioner was the group D. Petitioner's father was the group D. Your Lordship can see page 27. After compliance of the objection, school has sent the papers in 2023. Thereafter, next page 28, headmaster again sent a letter to the only death gratuity has been kept in next page 29. Again, raised objection of by the joint pension.
Yes, state.
My lord, since then there is a representation also pending. I see at the bottom,
Please
but
come.
kindly
The
allows
petitioner
us to take.
is the son of a deceased Group D staff of a secondary school. Staff. The employee expired on 12th of January 2004. Stop. Allegation is that his death gratuity has not been released till date. Stop. Document has been annexed to the writ petition in support of the submission that as late as on 24th October 2024, the DPPG returned the papers of the employee to the District Inspector of Schools, Secondary Education, Kolkata, for rectification of defects and for resubmission of the same. Stop. Nothing has matured thereafter. Stop. Paragraph. Prayer has been made to direct the authority to release the death gratuity of the employee. Stop. Learned advocate representing the state is not ready with proper instruction. Stop. Paragraph. As it appears that the employee retired, died in harness more than 20 years back, it is high time that the authority take prompt necessary steps for disbursal of the death gratuity of the employee. Stop. Paragraph. The instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Kolkata, to take all necessary steps to ensure that the terminal dues of the deceased employee are released at the earliest, but positively by 31st of March 2026. Disposed. $16.
No.
All right.
Pursuance of my lord's last order, the DI or
Yes, the District Inspector of Schools, Secondary Education, Malda.
ম্যাডাম আমি উপস্থিত আছি মালদা ডিআই সেকেন্ডারি
Yes, yes. What is the position now? You have rejected the prayer of the petitioner for being transferred to any of the schools in Malda.
ম্যাডাম ওনার যেটা হচ্ছে নোটিফিকেশন নম্বর 79 2016 সালে যেটা নোটিফিকেশন আছে সেখানে যেটা বলা আছে যে সেম ক্যাটাগরি এবং সেম পোস্ট হতে হবে।
শুনুন ডিআই মশাই, এখানে একজন ভদ্রমহিলা এসেছেন, তার একটা ছেলে আছে who is suffering from some ailment, physical ailment. I do not want to know what is the notification, the number or anything. Please identify a school where this teacher can be relocated. Please do whatever is required to be done. You can rely upon any government orders. Even if there are no government orders, somehow this lady has to be relocated. And this is for the best interest of the special child. What can you do?
ম্যাডাম আমরা তো ট্রান্সফারটা করতে পারি না, ওটা হচ্ছে যেটা গভর্নিং বডির আন্ডারে আছে, সেই গভর্নিং বডির আন্ডারে যেসব স্কুল আছে নোটিফিকেশন অনুসারে তার মধ্য থেকে ট্রান্সফারটা হবে। এছাড়া কিন্তু মানে টোটাল যে স্পেশাল রুলস আছে, স্পেশাল রুলসের মধ্যে 23খানা
The District Inspector of School Secondary Education Malda is virtually present. Stop. He has expressed his inability to provide any relief to the petitioner for her relocation in any school in the district of Malda. Stop. In such a situation, the court is compelled to direct the Commissioner of School Education to take a decision upon sympathetic consideration of the special request of the petitioner for relocating her to a school within the district of Malda so that she can remain close to the special child, close to the child having special needs. Stop. The Commissioner of School Education shall take a decision in the matter and place the same before this court on the adjourned date, released on the 5th of January 2026. Learned advocate for the state respondents shall communicate this order along with a copy of the writ petition and all other previous orders passed in the matter, so that the Commissioner of School Education can arrive at a just decision in the matter. Stop. A positive report from the Commissioner of School Education is expected on the adjourned date. Next. Presence of the DI stands dispensed with. 17. Yes, please. What is the submission?
Whether there is a GO government order other than 600. The specific instructions are that it is operation. There are no other government.
I'm providing one actually only name of the school is changed and the date is changed. Otherwise, no change. When I'm covered by your lordship's order, there is no such a thing. Kindly pass it on. That government can get the customer.
There is a very recent order. In fact, today also an order has been passed relying on the order of the authority, where there is increase of the this cap. Yes.
That is why it has been in bold.
You know, the first order,
I cannot remember exactly, but then today morning I passed order.
you not follow the also the same line that you cannot get them. There should be no excel to determine the financial condition of the
here whether apart from taking the no other
And see page, they are calculating only pension. Page my lord 35. Only pension is given. And 2000 more. And it would be. Page 35. Only pension. No other income. I have not rejected, only they are out. I have not rejected the plan.
Are you aware of the order that your learned senior friend is relying upon? Yes. Similar issue was considered. Right.
So kindly add this, you should recommend the matter to the SSC for my appointment. But now the SSC is the authority, I have made the SSC as part. Similar Murshidabad PI. That was also rejected.
Please come. The father of the petitioner was an employee, was serving as an assistant teacher in a secondary school, in a high secondary school in the district of Murshidabad. Stop. He died on harness on 30th September 2023. Stop. The daughter of the deceased teacher seeks compassionate appointment. Stop. Her prayer stood rejected by the District Inspector of Schools by passing a reasoned order, relying on the government order number 697 -ES/S/IS/18/08 dated 9th July 2009. Stop. According to the authority, the pension that is received by the widow, pension, a family pension received by the widow, is more than the initial gross salary of a Group D staff of the state government for a month. Stop. The same is impugned in the instant writ petition. Stop. Submission is that the authority ought not to take into consideration the amount mentioned in the amount payable on account of family pension for considering the prayer for compassionate appointment. Step. In support of such submission, reliance has been placed on the order dated 24th November 2021 passed by the court in WPA 15954 of 2021 in the matter of Muhammad Shahnawaz Ali versus the state of West Bengal and others, wherein under similar circumstances, the court was pleased to set aside the impugned order of rejection for being considered for appointment on compassionate ground. and remanded the matter back to the authority for fresh consideration. Stop. Paragraph. In Muhammad Shahnawaz Ali within brackets Supra, the court held that receipt of family pension cannot be a valid ground for rejecting the prayer of the heir of a deceased for being appointed on compassionate ground. The same cannot stand in the way of consideration of the case of the heir independently for grant of appointment on compassionate ground. Stop. The prayer for compassionate appointment is to be considered without taking into consideration the amount received by the widow as family pension.
Grateful.
Stop. The facts of the present case being similar to the one in the matter of Shahnawaz Ali, the court is inclined to pass similar direction in the instant case. Stop. The impugned order of rejection passed by the District Inspector of Schools, Murshidabad, is Murshidabad on 24th April 2025 is set aside. Stop. The matter is remanded back to the DI for consideration of the prayer of the petitioner for grant of compassionate appointment, strictly in accordance with the observations made herein above, and in line with the law laid down by the court in the matter of Muhammad Shahnawaz Ali within brackets Supra.
Within certain time and after giving an opportunity.
A decision shall be taken by the authority at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The aforesaid respondent shall pass a reasoned order and communicate the same to the petitioner immediately thereafter. Stop. If the prayer of the petitioner is allowed, then the documents of the petitioner shall be forwarded to the School Service Commission for taking necessary consequential steps.
For appointment.
Read petition stands disposed. Instruction forwarded by the DI, Secondary Education, Murshidabad, dated 5th December 2025, be retained with the record.
Only one sentence after adding and after giving an opportunity of hearing, so that we can place
The
the dots.
opportunity of hearing shall be granted to the petitioner prior to passing a final order in the matter.
I'm grateful, ma'am.
My lords, my lady 18 is identical to 41. This pertains to after the extended panel. So that's similar to what my lady heard in 41.
There is already an order, identical order for production of expiry panel. And this case involves prayer A, C, D, rule challenge, expiry, and also asking for tentatives. All three are there, which I was saying that all are involved.
In the last order, manual, there was the direction for production of the
list. Yes. I'm saying.
May I place, Milord? I have one submission to make, Milord, for commission. Milord, in the at 2 o'clock, Milord, we placed 3 panels before your lordship. The panels containing names of the candidate who are appointed at after 4th counselling. Milord, till 8th counselling. Milord, there is another list of 65 candidates which was inadvertently not placed, Milord. These candidates were appointed pursuant to court's direction of 14 December 2022. Milord, may I place that order and the list as well, Milord? It may be taken on record and kept with the other 3 lists, Milord. Milord, there is an order of 14th December 2022, Milord. Passed in
done separately because other matters lordship is going to take on 13th.
Milord, may I make my submission? There is an order dated 14th December, Milord. Kindly takes paragraph 2 of that order.
Yes, paragraph 2.
Milord, on August 2020, 181 candidates were recommended, out of which, Milord, 102 did not join. So, Honorable Single Judge, Milord, in that matter, directed us to fill up those 102 vacancies, which are unfilled according to the board's report. and recommend candidates as per their merit and category. This was done on 14th of December 2022. Pursuant to this order, my lord, we recommended another 65 candidates on 14th of December, my lord. Another list is there, my lord. My colleague will place it before your lordship. My lord, may that list be taken on record and kept with the other 3 lists, my lord. These are all the
But then,
candidates.
if there was 102 vacancies, why did you recommend only 65 names? What about the
65
others?
were recommended as per our instructions, my lord. Only 65 were recommended.
Why did you not recommend the names of the others? Total 102?
I'll take instruction and deal with that point, my lord, in my affidavit, my lord. But 65 names were recommended. Apart from this, my lord, in 2023, in two different matters, more candidates were recommended. Pursuant to Honorable Justice Vishwajit Basu's order, my lord.
All
So, my
right.
lord, can
If
you
you have
wait-
orders in your support, it is all right. Please
But we'll
produce.
place that, my lord, but kindly take this list as well, because this list will also include the candidates who were
One of
recommended after.
the lists possibly I have returned. That is the list of tainted candidates that you give. ওটা ফেরত দিয়ে দিয়েছিলাম না? That was returned. Only 2 lists were retained with the records.
There would be 3 lists, my lord.
Three
One
lists
of
were there.
9, 10.
Apart from that voluminous one. 3 including the voluminous one.
My lord, there were 3 lists. One for
One
class
is class
9.
9, one is class 11. Those 2 have been retained.
My lord, 9, 10 has 2 lists, my lord. One is except Bengali and one is list of Bengali of class 9 and 10.
I saw only Bengali graduation.
My lord, there is another list which has candidates except Bengali. My lord, that's the bulky one. 45 pages list, my lord. It has the majority of names.
Give.
My lord, that list is of 45 pages, my lord. It has 1547 names.
1 minute. Possibly these 2 were retained and the voluminous one was returned. Yes. Right, there were 3 lists. That is 65. All doesn't matter. I'm retaining all these.
In total, my lord, there will be 4 lists, my lord.
এইটা ফেরত দিন, এটা দুবার এসছে। This has come up twice. So I have in front of me 4 lists. One is of 65 recommended candidates. The other is the candidates, untainted candidates recommended after the 3rd phase, classes 11, 12. Candidates recommended after the 3rd phase, 9, 10, Bengali, and other is except Bengali.
Well, in fact, I was referring to this order that Lordship has already taken care of by directing that this should be produced before your Lordship during this decision, which would be taken ultimately by your Lordship.
Please come. 4 lists containing details of candidates. Recommended. Now do one thing. 3 lists, Karun. 3 lists. The candidates who were recommended after the 3rd phase of counseling in connection with first SLST, 11 and 12, comma, 3rd phase of counseling in connection with 9 and 10 in Bengali within bracket GRAD, and the list recommending candidates after the 3rd phase of counseling in connection with 910 except Bengali within bracket GRAD, and a further list of 65 recommended candidates in compliance of the order dated 14th December 2022 in WPA 13700 of 2021 within bracket Setab Uddin, separate, and others versus the state of West Bengal and others have been produced in court by the learned advocate representing the commission. Let all the 4 lists be taken on record and retained in a sealed envelope. The respondents are directed to file their affidavit in opposition by 23rd December, reply if any by 6th, released on 13th.
My lord, in this matter, my lord, I am appearing for the CAN applicant number 2, and my lord, I have moved, my lord, another CAN, that is, my lord, CAN number 7, my lord, which is, my lord, is not in today's list, my lord. I am seeking, my lord, improvement, my lord. So your lordship would be kind enough to, my lord.
Who are
My
you?
lord, I am, my lord, representing the persons who are, my lord, out of panel.
Out of panel means?
Expiry of the panel. The people, my lord, appointed after expiry of the panel.
That means similarly placed. There are other similarly placed applicants over here.
So, my lord, CAN 7, my lord. CAN 7, my lord, I have already, my lord, served. Your lordship.
Upon whom?
Upon the, my lord, petitioner, my lord.
The learned advocate says copy has not been served.
My lord, my advocate on record, Mr. Boyle, is there in the court. He must be, my lord, having affidavit of service.
But I have not been served.
List আসেনি, treated as on days list and allowed.
My lord, for a change.
And added. আর reasoning টা এখানে দিয়ে দেবে। এই যে 4 will be there, 5 will be there. ঠিক আছে? Copy of the application shall be served upon the learned advocate for the petitioner if not served earlier.
Grateful, my lord. And my lord, I also have a, my lord, preliminary objection with regard to, my lord, mandatory of this writ petition, my lord, that may be not considered.
অনিমেষ বাবু একটু দেখবেন তো 7 এসছে কিনা, CAN 7. When did you file CAN 7?
My lord, I have filed it on, my lord, yesterday, my lord.
That is the reason.
Yes, my lord.
That is the reason. It will be treated as on days list and it is disposed of.
My lord, kindly, my lord, record, I have, my lord, a preliminary objection regarding mandatory of this writ petition.
Take whatever objection
Grateful,
you
my lord,
feel
grateful.
like.
Grateful.
Nobody is standing in the way.
My lord, I am for applicants in CAN 1. I have been added by an order dated 28th of November. My lord, I am filing my affidavit in opposition today.
Today?
Yes.
Give.
And I shall circulate the copies among all the.
Please give. Where is it? Acha, if it were in opposition by the applicants in CAN 1 of 2025, filed in court is taken on record. Stop, let copy of the same be circulated. আসেনি? ঠিক আছে, এসে যাবে।
Well,
এটাকে
for a change in this matter, I am appearing for the respondent because in this case they have picked one of the persons post expiry of the panel and I am appearing for.
আচ্ছা, এখানে appearances গুলো একটু দেখবেন ঠিক করে, লাস্ট টাইম appearance গন্ডগোল হয়েছিল। Please put down in a piece of paper because in the last day's order, possibly there was a mistake in your matter only.
CAN 2, if there was a mistake.
Yes. Give it down in a piece of paper so that proper appearances can be recorded.
I am filing the opposition. For CAN 1.
Backsheet আছে? Backsheet? আপনাকে খুলে সেলাই করে yes,
so
let them do it. You don't take the responsibility.
But I appear for the added respondents.
But I'm appearing for the commission in this.
I appear on behalf of the petitioner, my lord.
Follow list.
Yes, my lord. I am appearing on behalf of the petitioner.
Can 7. Last matter you said that submission was that the matter is not there in the list. I can see can 7 in the list. You are so very excited you did not find time to look at the list.
But can 7, but it appeared it was not in the list, my lord, to me, my lord. I was instructed, my lord, it was. I am so sorry, my lord.
এটা কোনটা হচ্ছে 19?
But I'm appearing for the commission in 19th. We were to take
Yes.
steps as per your lordship's last directions.
My lord, my lord, as per my lord's last direction, they not yet take steps, my lord. I will show one after another, my lord. Before that, my lord, after my lord's order, Supreme Court order was passed, my lord. I will place first on the Supreme Court order. Thereafter, my lord, I place my lord's order. May I read the Supreme Court order, my lord?
1 minute. What is the date of this order?
My lord,
19th November.
Paria, my lord. That is 26th November 2020.
This order is dated 5th of December 2025. So this order is order of this
Supreme Court order 26th
November.
Yes, my lord.
Thereafter, this court passed order.
Yes, my lord. Before that, my lord, so I place the Supreme Court order, my lord. Thereafter, I place my lord's order, my lord.
Your lordship's first order is important, 19th November order.
Oh, it's that order.
Yes.
All right, not the last one.
No, my lord. That is 19th November 2020.
All right.
I will place, my lord. Before, my lord, Supreme Court. Learned counsel for the petitioners stroke applicants seek permission to withdraw this special leave petition applications, reserving liberty to approach the High Court for seeking redressal of their lawful grievance in accordance with law. Permission granted. The special leave petition application are dismissed as withdrawn with the liberty aforestated. I just keep the diary number. Permission to file the special leave petition is granted. Delay condoned. The next paragraph is very important. We are informed that a writ petition being WPA number 26288 of 2025 has been entertained. So this instant writ petition is mentioned. Entertained by a learned judge of the High Court at Calcutta, and various issues were flagged by the learned judge in her order dated 7th November, 11th November, 12th November, and 19th November. That's my lord's order in respect of this writ petition, my lord. Passed therein, the matter on the file of this court as on date were kept pending only for the purpose of verifying whether the direction of this court in the state of West Bengal versus Boishaki Bhattacharya, Chatterjee and others were implemented scrupulously, as a learned judge of the Calcutta High Court has now taken up that issue also. We are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertake the exercise instead of this court. So, Supreme Court purpose is very specific, because Supreme Court pending this matter only for the reason of that whether the Boishaki Bhattacharya's order was scrupulously followed or not. For that reason, because my lord's taken up this writ petition, the Supreme Court says, as a court of first instance, the High Court, let's take up the matter. Now, the very next paragraph. It would be offend to all the petitioners stroke applicants, because before the apex court, they informed, directly they went to the Supreme Court against that order, and that various applicants says, we have also matter connected with this, because various prayers in this writ petition. I will place the prayers later on, my lord. Before that, my lord, I place this order. The High Court shall, however, ensure that this is the most important paragraph, my lord. The High Court shall, however, ensure that none of the tainted candidate are permitted to slip through in the fresh selection, be it on that or any pretext. So, my lord, the Supreme Court purpose to return back this petition is that none of the tainted candidate in any form, on any pretext, slip through the net. The High Court shall also ensure that means additional duty. High Court shall also ensure that the list of tainted candidate is placed in the public domain with full details so as to ensure that this does not happen. So, because of that, my lord, this is what my humble understanding is that, my lord, this is a continuation of first SLST 2016 selection process. The Article 12 authority, they made mistake, they did corruption, they did illegalities. It's a combination of three. For that reason, the first SLST 2016 was cancelled and set aside with a specific direction, return back to money, whosoever tainted candidate. Tainted candidate will not sit in the next recruitment process. But what is the conduct of the SSC and state? I will show one after another, my lord. What they did. After passing the judgment, my lord, Boishaki Bhattacharya, first time they tried to accommodate all the tainted candidate. In pursuance of court order, they are unable to do so in the first round. After Boishaki Bhattacharya. Thereafter,
how did they try to accommodate?
Because they try to accommodate tainted candidate, they give opportunity to participate in the tainted candidate.
Who were
That happened in July.
Not expiry panel, my lord. It's the first round. My lord, remember, Dolui matter, they try to, they take online application from the tainted candidate also. Kolkata High Court single bench, Honorable Justice Shogata Bhattacharya passed that order. No tainted candidate will allow. Thereafter, the state and SSC both went to the division bench. Division bench order. And that order, in pursuance of that order, there is specific mention, no tainted candidate will be allowed. Thereafter, they again allowed the tainted candidate. What they says, my lord, will remember, in that matter, my lord, they says no. We just only allowed that whosoever physically handicapped tainted candidate, they can pursue. My lord will remember. Thereafter, in pursuance of my lord order, they are unable to accommodate their position. They went to the Supreme Court. Supreme Court says no. There is no such tainted candidate, whether in the form of general candidate or tainted. So, in 2 rounds, the School Service Commission, first, they made mistake in that respect of 2016. Second round, they want to accommodate tainted candidate. Third round, they want to accommodate PH tainted candidate. Now, my lord, 4th round, I will show my lord one after another by dint of the Supreme Court order and my lord's order, comparing two, my lord. They again, my lord, give space to the tainted candidate. I will show my lord from the Supreme Court judgment itself. Learned Counsel in some of the cases seek relief in the terms of certain paragraph of the decision in Boishaki Bhattacharya Supra. They are at liberty to raise such hermeneutic exercise before the High Court. The special leave petition application are disposed of the aforesaid terms. Now, my lord, very next paragraph is very important. All, my lord, Supreme Court, my lord, consciously did it, and I will explain why this consciously did it. The High Court shall examine the matter uninfluenced, the most important word, uninfluenced by any of the observation on merit made by this court in the orders passed after that decision in Boishaki Bhattacharya Chatterjee Supra. Supreme Court gave all the power to the court of first instance, even which was the order form passed. It might be any type of order that is uninfluenced. So that order is not even binding upon the single bench. Supreme Court unequivocally says so. Now, my lord, the High Court shall also be mindful of the fact that the untainted candidates, that not untainted employee or untainted teacher, untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected by application of the new rules. That is the West Bengal School Service Commission selection for appointment to the post of assistant teacher for upper primary level of classes, except work education and physical education, classes 9, 10, and 11, 12 rule 2025. So that is the Supreme Court. The Supreme Court says, as per my humble understanding, two things. One is that no tainted candidate in any form or any pretext is allowed in the present selection process, number one, and court of first instance will ensure it. That is a bounded duty upon a court of first instance by the Supreme Court, number one. Number two, any order passed in the meanwhile, after 3rd April order, uninfluenced by that order. That is most important. Now, my lord, I will show, my lord, the Supreme Court judgment, that is Boishaki Bhattacharya judgment. Boishaki Bhattacharya copy the. What was there?
We are already nearing 4:30.
Then kindly keep this matter, my lord, tomorrow as a top matter. Why? I will explain, my lord. Because of that, my lord, this is not about, I follow what fallen from my lords. My lords have that power. My lords can even alter even after selection. But with my humble understanding is that, my lord, the Constitution, my lord, give this duty to any judicial authority or executive authority, act in aid of the Supreme Court, that is Article 144. And not only that, my lord, Supreme Court specifically in this matter. Why Supreme Court give this duty? Because of that, in pursuance of Supreme Court judgment, that selection process was set aside. Thereafter, my lord, in pursuance of Supreme Court order, this selection process is going on. And not only that, they advertise it in that form. So if in pursuance of Supreme Court order, this selection process is going on, and that instant selection process, the tainted candidate again take place, my lord. I will show even they place 4 list. I can show from the judgment itself. They consciously not place another list. What type of list? I'll take just one paragraph. My lord, para 37 of my apex court judgment. Para 37. They consciously not did it. And that is, my lord, what my learned friend says, that is in Setabuddin matter, in the pretext of something else, my lord. That was my matter. I know on which pretext, my lord, that order was passed. Kindly take, my lord, para 37, a chart. A tabular chart. My lord, assistant teacher for classes 9, 10. WBSSC recommended 11,425. Now, my lord, number of appointment letter issued by the board, excess 1071. Board is party in the instant writ petition, my lord. Whether board places that list, who are that excess candidate? No. They also slip through. They also sat in this as a tainted candidate. Who are that? These two authorities, my lord, will remember on the last occasion, I suggest one thing, because I believe, my lord, everybody will accept that. What are our endeavor? Right of employment is not given in our constitution, but equal opportunity in public employment, that's my fundamental right. I believe everyone's endeavor is that let's make this selection process a fresh but in a fair manner.
Well, only one small interjection. If my learned friend makes submissions which touches upon who are tainted, meaning thereby whether expiry panel, those persons are tainted or not, then my lord, I would be only requesting that lordship take it finally as lordship is doing it. If his prayer, interim prayer is anything other than that, I have no difficulty.
Yes,
but ultimately your lordship has to decide that the tainted means exactly what. Does it include all who have been appointed after expiry panel, or the Honorable Supreme Court use this term exactly for some specifically tainted persons in the specific paragraphs in the judgment of the Honorable Supreme Court? All I'm saying that lordship will decide it, but what my learned friend wants it, ultimately, my lord, whatever he wants, it will have a
Touch the
bearing.
panel.
It will have a
touch the
bearing
panel.
on. He wants to have the panel. That lordship is passing the orders in other matters also. That should be produced before your lordship. No difficulty for that.
In my reputation, the expiry panel is not the only point. In my reputation, my lord.
So today another group comes in. That means excess appointment letters issued by the board.
Yes.
This list
Not only
is
that,
also
my lord, I
required.
have specific prayer regarding OMR sheet publication of 2 sets of selection process. One is 2016 selection. I have specific prayer as well as
2016,
entry.
the Supreme Court already granted order.
No, not yet, my lord. Because of that, Supreme Court take up that SLP, that is which evolved from that whether the High Court will take up that contempt or Supreme Court. That SLP is fixed on the month of January. So that yet not yet, my lord.
Right.
So my lord, in this interregnum period, I have threefold prayer as an interim prayer. Why? And I believe that is innocuous one, and that will not touch anyone. One is that, my lord, already division bench passed that order, 363 subpara 3.
No, that has been modified, my lord. Sorry.
Modified.
No.
Just wait, yes.
My lord, I just place my case, my lord, that is not 2025. I believe, my lord, if I stand corrected,
363,
2016 selection process,
yes.
OMR sheet ought to publish, my lord, 363 subpara. I have specific prayer as well as interim prayer also. Let's publish that 2016 OMR sheet. Let's publish 2025 OMR sheet. That is one of the prayer. Another prayer is that, my lord, my lord, I follow that case, my lord. They give 4 lists as per my understanding. One is 9-10, another one is 11-12, another one in pursuance of court order. Whosoever got appointment, they ought to give another list also. Maybe in a sealed envelope. Who are that excess candidate? And for that reason,
excess appointment
given by the board. Board. Why? Because of that, my lord, suppose they ought to sit together. SSC and board ought to sit together. Why? Suppose, my lord, a recommendation letter issued by the SSC. Now, my lord, due to wrong recommendation, there is a specific rule. Wrong recommendation, that recommendation cancelled and another recommendation issued. It not happen for every case. It might happen for some cases. So for that reason, to identify who are that excess appointees, because in Group C, Group D, both the authority, SSC as well as the board, they give affidavit contrary to each other. For that reason, first time CBI investigation, because of that, they says, the SSC says we never recommended, and the board says yes, we got that recommendation. For that conflict, first time the CBI investigation. So, my lord, for that reason,
is the board here today? Board.
Board is.
Yes, Calder, she's coming. All right.
So, my lord, so for that reason,
it's already 35. Take note. Yes.
For that reason, my juniors and both, if my lords want, because I will make submission, my lord, I believe, my lord, it will be beneficial for everyone. Whosoever sat in there, who will be successful one, and that will instill the faith on that Article 12 authority. My whole endeavor is that, my lord, make this selection process, my lord, fair and transparent. That's of my whole endeavor, my lord. And Supreme Court, on that score, my lord, entrusted this court, my lord, with a particular observation and give unfettered power, even uninfluenced by any order. So, my lord, it will be kind enough, my lord, if my lord take tomorrow, my lord, I will not take more than 5 to 10 minutes.
But tomorrow, that appeal of that SC/ST matter, that is there fixed.
My lord, on 19th of November, your lordship had directed us to respond to paragraph number 7 names mentioned in paragraph number 14 of the writ petition.
All right.
My lord, we have prepared a report with respect to 14 those 7 names which are mentioned in paragraph number 14 of the writ petition. My lord, this allegation was not raised on 19th of November. My lord, we will take instructions. We'll revert back tomorrow or whenever your lordship is fixing the matter next, my lord, and Preliminary, my lord, I have received instruction in other matters because people have challenged that those candidates in whose favor appointment letters were issued but recommendations were not made, they were out of panel candidates. My lord, preliminary, my lord, I can recollect I have received such instruction, but I will take specific instruction on that issue, my lord. So what has been submitted, my lord, perhaps is not correct. My lord, we'll take instruction, we'll revert upon back to your lordship, my lord. Kindly fix it, my lord. A week hence, my lord, we'll revert with reports as to what is the correct factum with regard to paragraph number 37 of Supreme Court order, which my learned senior is placing before your lordship, because this was not placed on the first occasion. On the first occasion, your lordship directed us to.
This is not such a short matter that it can be done so easily and just one go, right? Today one paragraph, tomorrow another paragraph, somebody showing 31, somebody showing 37, somebody 49, 46, 363. So many paragraphs and so many orders to be read in conjunction.
Yes.
So, and this little bit of haphazardness will be there. And everybody has to accept it, and we have to adjust ourselves to that, right? So here it has been pointed out that there are excess appointment letters issued by the board. So in whose favor these appointments have been made? These candidates are not there in the panel. Just now you mentioned they are out of panel.
Out of panel list, my lord, is there in the tainted list. Those candidates are featured in tainted list.
Very well. If the list from the board is produced and the same names tally, then it is all right. You do not have a difficulty, isn't it?
We are not standing in the way.
I understand. Nobody is standing in the way, but the fact remains that the teachers are the worst sufferers and the beneficiaries of the entire issue is the legal profession. Nothing and nobody out of it but the legal professionals.
For which the legal profession is meant.
Certainly it is meant. It is meant for the other litigants also.
Yes, yes, madam.
The matter is consuming so much of time. It has already consumed so much of time.
There would be a respondent.
Certainly, obviously, it has to be.
If there would
Where
be
is
court, there would be us.
board? Not yet come. All right. Tell her. Paragraph 37 of the Supreme Court's order, dated 3rd of April 2025. There is a chart. There is a chart in paragraph 37 of the Supreme Court's order dated 3rd April 2025, where there is a mention of excess appointment letters issued by the board. Please produce the details of the candidates in whose favor these appointment letters
No,
were
well,
issued.
in this respect, my lord, when the matter was before Justice Justice Gangopadhyay, Lordship, I have when this excess came first, it came before the
where it came, I do not know.
I have filed, board has filed an affidavit stating regarding Group C, Group D, stating that we have received all recommendations and thereafter we have issued the appointment letters.
So this is not in group, not in classes 9, 10, 11, 12?
No, that was in respect of Group C and Group D.
Here, excess appointment letters. I can see 1071, 910, 199, 11, 12. How can you say it is not there? It is there.
I give the clear picture of
this
that.
has been clarified afterwards by an affidavit in Supreme Court also. No, no.
Yes.
If I am not mistaken, this has been clarified in Supreme Court also. That what happened, Your Lordship, SSC issued a recommendation letter, board issued appointment. That person did not join, prayed, I will not join there, I will join somewhere else. Again, our recommendation issued. Again, an appointment issued, cancelling that one. When this was put, my lord.
Very well. You bring the list. Yes. You produce the list of these appointment letters. Details of the candidates in whose favor it has been issued, and this matter is in respect of 9, 10, and 11, 12. So we'll bring 1071 and 199.
Well, who is this 1071? Because
that
we are
you
saying
will
that
know.
We are saying that
I do not know. It is in the Supreme Court's order. I do not know this figure. The court is not imputing over here.
And my lord, another thing is that
This is the entire list, your lordship, in favor of which we have received the recommendation and we have issued the appointment letter.
another
Because we have denied this portion, my lord. That is in the affidavit. We have also filed it. I'll file a report with your lordship annexing all those things.
my lord, another thing I just
Yes.
pointed out that regarding tainted list, my lord will remember in group C, group D matter already they my lord para 25, my lord. My lord, they in that table, my lord, they accept that my lord, can it turn para 25 of that Supreme Court judgment. There is OMR mismatch 952 in the category of 910 and OMR mismatch in 1112 907. Out of that, everybody not got appointment, but they ought to publish that tainted candidate list. Out of 952, 808 got appointment, but others, they are also tainted because their OMR sheet, suppose they not got.
How many names have been published? 952?
1806 candidate, and that ought to, that number came up to 2082. So if I add 952 plus 907, add 185 plus 38. As per this two list, tallied this.
Commission, the table at paragraph 25 of the Supreme Court's order.
Not the excess candidates who did not get appointment, those lists that is, it is being prepared. I have instructions that it will be published within 2 or 3 days.
All right, please publish it.
Yes, that's direct. 1806 they publish. They ought to publish 208.
1806 is a list of appointed tainted candidates.
Yes, do not publish that.
Not appointed,
Not published.
but
Featured in the CBI's list.
Yes. 952 plus 907, whatever is the figure, please publish.
It will be around 100 or 200, not 952, because out of this 808 got appointment.
Right. So the balance.
Balance.
Regarding expiry panel?
Heard submission made on behalf of the petitioners. Stop. Attention of the court has been drawn to paragraphs 25 and 37 of the judgment passed by the Honorable Supreme Court on 3rd April 2025. Stop. Prayer has been made to direct the Commission to publish the list of the candidates who were not appointed but have been found to have the OMR score mismatch. Stop. Prayer has also been made to direct the West Bengal Board of Secondary Education to produce the list of candidates in whose favor the board issued appointment letters in excess of the recommendation made by the Commission. Stop. Next. The hearing of the matter stands adjourned till 6th of January 2026.
I may file a report with them.
You choose whatever you feel like.
Item number 46 is, my lord, I'm challenging the list of the candidates on 2 grounds: that persons who are not tainted have been included and the expiry panel has also not been included. Group C, Group D. The matters which are
These are all the teachers. 80s.
So therefore, my lord, item number 46, if your lordship kindly takes up, my lord, tomorrow, so today it will not be.
They want
The matter is there in the list.
My lord, if your lordship, because the other matters are being taken up and fixed at 6. So therefore, and there is an order for production. And in that matter also, there might be a Malalbi praying that the order of
As and when it is taken up, it will be done. It cannot be done out
can
of
he clubs all the SLSTs, my lord, then my lord.
It has been clubbed. Even then, all
Get to
SSCs,
46, it is all SLST.
all. And it
76.
matter. The shades are different.
Yes.
You have heard of 50 shades of grey. Here 500 shades of SLST, second SLST. Right? So you have
That matter, if that matter also, I'll try to, my lord, read the order.
Alarm bajenge.
Alarm yes.
That was it.
So that is the ultimate warning that lordship should rise. When tomorrow, my lord, tomorrow, my lord, because
Grateful, my lord. Yes.